start talking. We're going to talk about the course objectives first. So our objectives are to talk about the purpose and duties of your association, the roles and responsibilities of the directors and officers. We're going to talk about your governing documents and what you would find in those. And then we're going to talk about statutes that apply to an HOA or a condo. And we're going to focus on two sets of statutes. Chapter 718 applies to condominiums. Chapter 720 applies to homeowners associations. There's some overlap between them, but they're very different. There's also some other statutes that we'll talk about that apply from time to time, and we'll get into those as well. So, and then we're going to talk about the roles and responsibilities of the association members, because they also have responsibilities. Okay, so first we'll talk about the purpose and duties of the association and the board. You can go probably 2 slides over. Okay, so your association. So what is the purpose of the association? Your purpose is to manage and maintain the common property for the benefit of the community. And you're also responsible for enforcing your covenants. And one of the things I talk about in terms of, there's been some questions as to what is the purpose of a homeowners association, and or condos are a little more defined in the law, but there's been some questions raised recently as to why do we need homeowners associations, and maybe we could just do away with them. And there's actually been some consideration in legislation about doing that. And one of the things that a homeowners association and a condo association will do is they maintain property to a higher standard per your governing documents. So we can all live in the city or the county, and you have code enforcement that keeps property to a certain standard in the city or the county. But in a homeowners association, everybody has moved into a certain area and agreed to abide by a certain standards. And so it's incumbent upon everybody, the board and the members, to comply with those standards, because that's basically what you've agreed to by moving into your community. So how do we maintain and manage our property? So the association has to establish a budget. You have to have reserve accounts. This is very important in condominium associations, and we'll talk about all those issues. Also very recommended for homeowners associations as well, but not required. You charge and collect assessments from your owners to fund that budget. You can enter into contracts for maintenance and repair, and you enforce your governing documents. And we're going to talk about all those things in a little bit more detail. Okay, so association duties per statute. So chapter 718 applies to all condominium associations in the state of Florida. And chapter 720 applies to all homeowners associations in the state of Florida. So everybody has to abide by the statute. And then each community has its own set of governing documents. So, and there's a lot of overlap, but they're all different. Yeah. And so each community is unique, but then you have these statutes that everybody has to abide by. There can be conflicts between the statute and your governing documents, and we'll talk about those because it's not always clear which one takes priority, but we'll talk about that. So duties per statute: operate, manage, and maintain common property, enforce your covenants. Your association can sue, can file lawsuits, and can be sued. Your association can enter into contracts, which is an important right. Obviously, making and collecting assessments, and then the right to lien and foreclose your non-payment of assessments. That's an important right that needs to be in your governing documents, and is also provided in statute. If you're in a condominium, you have a statutory right of access to the condominium units. Not in an HOA. So if you're in an HOA, you can't go into somebody's house. You may be able to go onto their lot, but you can't go into the house. But in a condominium, it's important to have access to the unit, because if there's, say, somebody's on vacation and there's a water leak in that unit, it could be affecting many other people. And so the association needs to be able to have that access. Insurance coverage, very important. There are different requirements between condos and HOAs. But we'll talk about some of the critical insurance coverage. You have to maintain official records. This is part of your reporting duty to your owners. So you have official records so that owners can always access those and have information about what is happening in the association, how their funds are being spent, that kind of thing. Financial reporting, another duty to your owners. Noticing and conducting meetings. And then there's a new requirement for preparing hurricane protection specifications, which I imagine is probably pretty unique to Florida. So, we'll talk about them. Okay, board of directors. So everybody here, I believe, is on a board of directors. So who are our boards? They're the members of the community that are elected or appointed to carry out the duties and responsibilities of the association. So the board is a governing body. It's usually 5 members, but it can range anywhere from, we've seen as few as 3 is the smallest, and then I think I've seen 9 or more, but 3 to 7 is pretty much the average, and 5 is kind of the sweet spot. And so that board works to carry out the duties of the association. So no one board member has more power than the other, and the decision of the board is the action of the association. Okay, so your board members want to act in good faith with diligence, care, and skill. What are our characteristics of a good board member? So, I know, I'm sure everybody wants to jump in, and I'd love to get input, but for time's sake, we'll just go through these and take some questions later. So anyway, so caring about the community, obviously that's critical. Promoting community involvement and positive solutions. So what do I mean by that? So what we see often is people who are typically not on the board, and sometimes people on the board are critical of decisions and actions of the association and the board. And it's, as a board member, it can be frustrating to hear those criticisms. But one of your jobs is to try to promote solutions. So if an owner is complaining, well, what owner would you like to see us do differently? Like, just don't tell us how terrible the landscaping is. Tell us, what do you think needs to be done, and promoting those sort of positive solutions. And then akin to that, a good board member should be able to handle some criticism. There have actually been changes in the statute that have baked this into law. But I do hear a lot of board members that are upset, rightfully so, when owners complain about them, which tends to happen on social media. So I'm not a big fan of social media. I don't know if everybody else is, but because what I hear about social media is the criticisms that people make of the board, and the board members take that to heart. And I am suggesting to you not to take that to heart. People will make criticisms of the board, and they are entitled to do that. They're not entitled to defame you, but they can criticize. That's their job. And it's important as a board member to hear the criticism, to not take it personally, but to consider whether there's some merit to it that may be helpful in your decision making. But don't take it personally. That is my one piece of guidance for folks, because I do hear a lot of board members get very upset about what's said, as particularly online. Okay, so how can you be eligible to be on the board? Typically, you have to be a member of the association. Some of you may be surprised to know that your governing documents may not require board members to be members of the association. And that's because when the developer formed your association, they did not require board members to be members and residents of the community, because they wanted to put their developer appointed directors on. So some of the more well-written bylaws provide for a transition that after turnover, all members of the board have to be members of the association and owners of property in the community. Some don't do that. So there can be times when you have the ability to be on the board, even though you're not an owner in the community. But we certainly encourage, if there's going to be a vote, that owners look to vote for board members who are also owners of property in the community, because they have the vested interest in maintaining the property and maintaining the property value. Okay, not delinquent in your monetary obligations to the association. So on the date the nominations are due, you have to be current on all assessments, special assessments, fines, whatever that are owed to the association in order to be a candidate for the board. You cannot be a convicted felon, or if you were a convicted felon, you need to have had your rights restored for the past 5 years. And that does happen from time to time. We've discovered board members who have had felonies in the past that disqualify them from being on the board. There's some new changes that provide that if you're subject to criminal charges, particularly related to operations of the association, you would not be eligible to be on the board. Taking kickbacks, theft of association property, things like that. Okay, so you may have heard of your fiduciary duty as a board member. So board members have a fiduciary duty to the owners. So what does that mean? A fiduciary duty arises because you as board members are charged with handling property of the owners, their assessments, that money, and then also the common property that's owned by all of the owners in the HOA or the common areas or the common elements. So because you have the responsibility to manage that property, you have a fiduciary duty to the owners to do so in the best interest of them and the community. So the way that you do that is obviously if you're acting in the interest of the community, you're typically meeting your fiduciary duty. You breach your fiduciary duty if you're acting self-interestedly. So if you're self-dealing, if you're committing fraud, if you're betraying the trust of the owners, theft, things like that, those would be breaches of your fiduciary duty. I've had questions arise sometimes because there can be issues that come before the board that the board has to vote on that may be of particular interest to one board member over the others because it pertains to their building or their section of the community or something like that. That doesn't mean there's a conflict, right? You have 5 board members, you're representing 5 different perspectives of the community. You may be representing, there may be townhomes and single family homes all on one board. So you're representing those different interests. It is okay for you to vote on those and it's not a conflict of interest. As my partner says, a rising tide lifts all boats. So if you're trying to promote the best interests of every part of the neighborhood, that's fine. Self-dealing is more like, you know, if you had a painting project and your community was not due for painting for like 5 years, but you on the board, you're about to sell your house and you want to, you know, move that painting project up because you think it'll make your property more marketable. That might be getting into a little bit of self-dealing. But if it's due for painting and you want to sell your house and it's going to be good for you, well, you may want to take charge of that responsibility and push that project along. But as long as it's consistent with the interests of the whole community, then you're basically doing your duty. So there's other duties as well, in addition to your fiduciary duty, loyal to the association, duties of care, and then you have a duty of confidentiality. You as board members may come across information, and there are certain records and information of the association that are not subject to inspection and copying by the members. Things like obviously attorney-client privilege communications, information that you may get regarding medical or health information about an owner based on a request for an accommodation under the Fair Housing Act. Some leasing information you may get may be confidential, so you have a duty to maintain that confidentiality as well. Okay, education requirements. That's why you're all here today. Welcome. So previously, there was a requirement in the statute for HOA and condo board members that you had to do a certification that you had read the governing documents and that you had understood the statutes and you were going to abide by the governing documents and the statutes to the best of your ability. Then a couple years ago, many years ago, many they started doing these board certification courses to educate board members, but it was optional. A couple years ago, it became required. So here we are today. So within 90 days of being elected or appointed, you have to take a board certification course that is specifically geared towards new board members. If you're in a condo, it has to be a 4-hour course. If you're in an HOA, it doesn't necessarily have to be 4 hours. There's why the statutes are different, we're not really sure, but these are, I tried to kind of highlight the differences in the green versus the gold. The green applies to condos, the gold applies to HOAs. If it's in black, it applies to both. So if you're in the condo, you're going to deal with things like your milestone inspection, your structural integrity reserve study, and we're going to talk about those things, elections, and then for everyone, record keeping, finances, fines, notice of meeting requirements. So we're going to cover all of that. If you're in a condo, this certification is valid for 7 years of uninterrupted service. So as long as you're on the board for a continuous 7 years, you do not need to take this 4-hour course again. In a condo, you do need 1 hour of updates on changes to the Florida Condo Act every year. If you're in an HOA, if you have less than 2,500 units in your parcels in your community, you have to take this course within 90 days of being elected or appointed once every 4 years of continuous service. But in addition to that, you need to take another 4 hours of education on other things every year. So unfortunately, if you're in an HOA, you've got to listen to me or somebody else talk about condo or HOA regulations every 4 hours every year. What else? So if you're more than 2,500 parcels, it's 8 hours a year. And I will say, as somebody who's been doing this for a long time, the Florida Condo Act is more intricate and involved and detailed in terms of the requirements on Florida condominium associations than the HOA Chapter 720 is. So it's kind of, and there tend to be more changes to the Condo Act from year to year than to the HOA statute. So I'm not sure why they did the requirements that way, but it is what it is for now. So we will follow the rules. Okay, so now we're going to talk about conflicts of interest for directors. So you guys as directors can get into situations that are a conflict of interest, which goes down the road of reaching your fiduciary duty. So we want to avoid these things. And there are things so some examples of things that you can consider a conflict of interest. When a board member or their relative enters or proposes to enter into a contract with the association or holds an interest in an entity that may enter into a contract with the association. So if your brother has a landscaping company and they pitch to the association to be the landscaper for the association, you need to disclose that conflict to the board. And then the board has to vote on it, and it can be approved if 2/3 of the non-interested board members vote in favor of it. I will say this, I don't recommend doing that unless it's the only option. Because even if you can get it past the non-interested board members and they approve this, what we call a conflict transaction, there could be problems down the road, right? So say your brother's landscaping company, some employee gets drunk and they drive the truck into the clubhouse and they cause an accident. Well, now the association is going to be adverse to the company, and you as a board member are going to be adverse to your brother's landscaping company. So we want to try to avoid those situations, and it's just, if there's plenty of vendors and there's other options, you want to steer away from those conflicted or potentially conflicted situations. Okay, kickbacks. So there's some recent changes in the statute that very expressly prohibit kickbacks. Anything, item, or service of value for which no consideration has been provided. You cannot knowingly accept a kickback. Kickbacks can come up a little bit sneakily. So I had this happen in a HOA community in the Orlando area. the landscaping company, their contract was coming up for renewal. And one of the board members was on the landscaping committee or whatever. And he had communication with the company, and he said, hey, your contract's coming up for bid again. You might want to pay special attention to the board members' properties. And so the landscaping company did, and they provided extra services. I don't remember what they did. Maybe they planted extra annuals or something in the board members' properties without charging them for it. That is essentially a kickback. Now, the other board members obviously didn't know, so it wasn't a knowing thing. And there was no, we corrected it, but that is something that could be considered a kickback, and you want to be careful about that. Okay, and then board members and managers may not purchase a unit at a condominium lien foreclosure sale. I also would discourage HOA board members from purchasing a unit at a homeowners association lien foreclosure sale. You don't want there to be any suggestion or implication that a board member would have facilitated or pushed along a collection action, in order to acquire property, which I assume is what the point of that is. I don't know why else that would be there. Okay, so they director criminal offenses. So the legislature decided recently that they needed to add in certain criminal offenses that board members may be committing. And we believe a lot of these things arise from some problematic dealings with condominium associations in the Broward, Miami area. I don't see these things happen a lot, but they certainly could. So there can be criminal punishment and removal from the board for forgery of a ballot, envelope, or voting certificate in an election. Obviously, theft or embezzlement of association funds, that clearly would be criminal. Destruction or refusal to allow inspection or copying of an official record when it's in furtherance of a crime. Obstruction of justice, accepting a kickback. Use of debit cards for an unapproved expense. There's a couple places in the statute where the legislature discourages or prohibits using debit cards. So if your condo association or your HOA has a debit card, you might want to move on from that. Cut that one up. So if you are subject to your criminal charge, you cannot be appointed or elected, and you could be removed from office. And again, some of these things can come up very innocently. I've seen situations where somebody will get a ballot or a proxy, and the owner will have filled out the whole thing, but they didn't check the box on what to vote on. And somebody will say, well, I know Mary meant to vote in favor of it because she and I had a conversation about this just yesterday, and she's all for this amendment. Can I check the box for her? No, you cannot. So that, those are things you just want to be cautious about, and definitely err on the side of caution. Because now, with the legislature seeing fit to identify these as potentially criminal actions, you want to be especially cautious. We see, and I'm sure many of you have seen, there are sometimes owners in the community that are a little bit out to get the board. And so if they find some element of potential wrongdoing, they can make a big issue out of it, which, if nothing else, is just stressful for you. So, and we want to avoid that. So conflicts of interest now apply to managers. So your management company could be subject to some consequences for not disclosing certain conflicts of interest. So management companies must make certain disclosures whenever the management company or the manager or a director or officer of a management company or a person with a financial interest in the management company or a relative of any of those folks proposes to enter into a contract with the association for any goods or services except the management services, holds an interest in or receives compensation from any person or entity which conducts business with the association. This includes referral fees and profit sharing. So how this comes up, some of you may be familiar with this. Some management companies have relationships with vendors. Some management companies have side businesses. They have a handyman service, or they have a pool service, or they have a landscaping company. Some have, I've seen where they have a relationship with Spectrum, and they leverage the fact that they have many associations that they manage, which is a good source of business for Spectrum. Or I don't know if it's Spectrum, I don't need to pick on Spectrum, but some internet company. And they, and the company says, hey, you refer us to your association. If they sign us on, we'll give you some financial benefit for that. And that's okay, because by leveraging that their broad client base, they can get a good deal. And it could be a very good deal for your community. You could bring your rates down significantly. And so that's okay, but they just need to let you know. So you need to know, hey, this is the management company's landscaping company, or my management company is going to get a $3,000 benefit if I sign into this agreement with Spectrum or Verizon or something like that. So it's a disclosure issue so that you're aware. And then let's see, what else do I need to tell you? So any conflicts should be disclosed in the management contract, or on a board meeting agenda and in the minutes. And it requires 2/3 approval of the board, and disclosure to the members, at a subsequent membership meeting. And then if the manager must obtain competitive bids for any contracts over $2,500, unless those are already disclosed in the management contract. And then I just added, there's some new conflicts that can apply to architects and engineers who are bidding on or providing services related to your milestone inspection or your structural integrity reserve study. So I'm going to talk about that a little bit further, but they need to disclose. So if they're going to do your reserve study, if they intend to also bid on doing the work that may be required as a result of that study, they need to disclose that to you. And vice versa, if they bid on the work that needs to get done, they need to disclose if they participated in preparing the reserve study. So hopefully that makes sense. I mean, it's really just to make sure everybody has level information about, the role of the companies in these transactions. Okay, fraudulent voting activities. So there are quite a few instances where the legislature has identified potentially fraudulent voting activities, which could be subject to removal from the board or criminal, some criminal potential penalties. Okay, so willfully and falsely swearing to or affirming an oath or procuring somebody else to do so in connection with or arising out of voting activities, perpetrating or attempting to perpetrate or aiding that in connection with a vote cast, to be cast, or attempted to be cast. These, as you can tell, they left no stone unturned. These are very comprehensive. Preventing a member from voting the way they intended, fraudulently changing or attempting to change a ballot. Some of these are very broad: menacing, threatening, or using bribery or any other corruption to attempt directly or indirectly to influence, deceive, or deter a member when the member is voting. Giving or promising anything of value. So if you're running for the board, you cannot offer your constituents that you will wash their car for a week if they vote for you. That would be, right? You can't do that. You can't offer them a car. You can give them food, but it's only a little bit of food. So no gift cards to, it's true. If it's food related to political activity or something, that's okay. Oh, is it food service at an election rally is okay. But gift cards to Outback, not okay. So just be careful. I mean, there could be many things that could be considered, I don't want to say a bribe, but a promise of something in order to influence a vote. You don't want to threaten people. If you don't vote in favor of me, your assessments are going to triple. If you don't vote in favor of me, they're going to start towing your car left and right, things like that. So you can obviously say why you want to be a board member and give that kind of information, but No attempts to influence voting. And then there's, the next page has a couple more. We won't go into them. It's just sort of, you get the idea, right? If anybody's voting on an election of directors or an amendment or some other vote pertaining to the association, you can't influence their vote, you can't threaten them, you can't try to persuade them, you can't bribe them, and you cannot alter their documents. Even if they're standing there next to you and they say, will you check the box for me? No, I'm gonna hand you the paper and you're gonna check the box. And I did put a couple additional examples. Let's see, yeah, filling in a blank, offering services, threatening to bring violation actions, things like that. First degree misdemeanor, which is punishable by up to a year in jail. I didn't do criminal law, so I had to look that up. But I was like, oh, that's pretty serious. So, okay, strategic lawsuits against public participation. These have existed for a long time in Florida. They've just now applied them to condominium associations. I don't think this applies to HOAs, but if you're an HOA, I would also be cautious about the same concept. So a strategic lawsuit against public participation is basically retaliation against a person for addressing their grievance in a forum where they have a right to address them. So if I live in a community and there's something that's not being maintained or I think is not correct, and I contact code enforcement or the health department, I call the health department and I say, hey, my HOA is not maintaining my pool, the pool chemicals are off, whatever, it's a safety violation, I want you out here, and they won't respond, right? So you cannot bring an action against that owner in retaliation for them expressing their grievance. So I'm trying to, I have some examples on here. So it's very specific though. Okay, the association may not file or cause to be filed what we call a SLAPP lawsuit or retaliatory lawsuit, which has no merit. That's a little bit of a caveat, but if it has merit, that's debatable, right? You can't fine or increase that unit owner's assessments, right? It's discriminatorily, so it would be different for that owner. If you increase everybody's assessments, it's fine. But you can't respond to their threat by increasing their assessments, decreasing services to that particular owner, bringing or threatening to bring or using association funds to bring an action for possession or other civil action like defamation, libel, slander, or tortious interference. So examples, if they file a DBPR complaint, we're seeing those a lot. The division of condominiums role has expanded and people are using it. So if they file something, you can't retaliate. If they contact code enforcement, if they attend a meeting and they complain about the board, they say, you're spending way too much money. You spent down all our reserves. We didn't get anything for it. So I say, you gotta take a little bit of the criticism and say, okay, I hear what you're saying. That is not correct. And here are the books and records. Here's our financial audit that shows how we've spent money, and there's not been anything that hasn't been part of the budget or necessary for our community. But if they make those complaints, you can't retaliate. So, and this is another thing that comes up relatively innocently. It'll be like, there'll be some issue with that owner, like, well, their mailbox has been a problem for months and they don't really take care of their property really well. And now they keep complaining to the DBPR about us. You know what? We're going to send them a violation notice for all these violations and we're going to fine them. That's retaliation, right? That's what we can't do. So if you see issues, and we'll talk about enforcement later on, but enforcement has to be done timely and should not ever be done in response to an action by an owner. So be very careful about those things. So let's see, I think I put some more examples. Contacting code enforcement, And these are in the statute. Contacting some of these folks for suspected violation applicable to the condominium, organizing, encouraging, or participating in a unit owner's organization. I read this to potentially mean Facebook or Nextdoor. So if somebody has their Nextdoor page or their Facebook community page, which, as I see, is usually a forum for people to register all of their complaints about the community, and maybe talking about garage sales, I don't know, but it tends to be a lot of complaints. That you cannot retaliate against them, and I see this all the time. They're defaming me, Michelle. They're defaming me. They put all this stuff on Facebook. It's not true. Okay, there's a very, very broad distinction between what's your First Amendment right to freedom of speech and criticism, and then what falls off the cliff to defamation. Very hard to prove, very difficult, and that's why I say try to just accept the criticism for what it is. Alleging criminal violations of the Condominium Act, rules of the Condominium Division with any of these entities, law enforcement, state attorney, and DBPR. They have a catch-all. Owner exercises any right under the Condominium Act. You can't retaliate against that. Public statements critical of the operation or management of the association. If you've been on a board for a couple of years, you've probably heard a few of those. Just make sure that you're not specifically targeting somebody who's complaining. Okay, so now we're going to talk about the roles and responsibilities of the directors and officers. So this is my partner's favorite slide. We call it the stay in your lane slide. And it's the duties of the board versus the duties of management. So I added a little airplane there because you as the board, you're taking a 1,000-foot view. You are operating the community. You're making decisions about what's important for your community. You're prioritizing what actions are taken, or what are we maintaining this year? What does our service report, our reserve study say? What are our finances? And what order do we want to do these things? Do we need to change our documents? Are we happy with our landscaper or pool service? If you're not, then it goes to your manager, and your manager carries out the duties at the direction of the board. Your manager acts at your direction. I hear people a lot of times who are like, well, our manager told us to do A, B, and C. Your manager is advising. They give you guidance based on their knowledge of the business, on working with other communities, but you guys have to decide. So it's never your manager telling you what to do, it's your manager giving you information. Same thing with your lawyers and your accountants. We give you advice and guidance, but you guys have to decide. So I'm gonna have Mark talk about some of the different roles that we have on the board. So there's, and I'll let you go through all that.
All right, so if you're a member of a board, you may also be an officer of the association. And it's helpful to think of these as two separate hats that you may wear. Everyone on the board of directors each has one vote when deciding on matters. However, some of you may be assigned specific duties under an officer position that you have to do in addition to your normal voting rights on the board. Now, first of all, we have the president, which is the chief executive officer of the association. They are generally responsible for coordinating board meetings and preparing the agenda for each board and membership meeting. They conduct the meetings. They're typically the chairperson at the meeting. They make sure that everything is following the proper order, that you are complying with the governing documents and your operation of the meetings. The president will also call for votes on any issues. So you're deciding on issue A, you've had a chance to discuss and debate. They can close the debate and discussion and call for a vote of each board member. The president also maintains order during both member and board meetings. The president is usually the person designated by the association to sign and execute written documents, most of the time contracts. So if you enter into a contract with vendor for something such as lawn maintenance, the president is usually the person that will sign that contract. unless your governing documents or your procedures provide otherwise, sometimes there's some variety to what the specific officer does in a particular association, but this is generally stuff that the president does. And then the president is usually the primary contact person for vendors, for management, for legal counsel. You may designate one or two other board members to also fill in this role, but the president's usually the main point of contact for outside entities. Now, moving on, the vice president is the deputy president. We all know that. They serve in the absence of the president. Say you have a board meeting, president can't make it. You will step into the shoes of the president. So you will maintain order, you will call for votes, and then you're just the backstop for the president. If the board has anything else that needs to be done, you will do it. It's like I said, there's some variety in what officers are supposed to do in each association, and just do what your governing documents say there. Moving on, the secretary is the custodian of the official records and sort of the record keeper of the association. We'll get into this a little bit more later, but you need to maintain the governing documents, which includes your declaration, bylaws, articles of incorporation. Make sure that the association is maintaining all contracts that they are a party to, any insurance documents evidencing insurance coverage. Make sure that voting records are kept properly. Make sure you have a membership list, owner ledgers showing whether owners are on time with their payments or delinquent. Architectural review committee records are typically maintained by the secretary. Violation enforcement records, when a violation letter is sent out, or when you refer a violation to legal counsel for additional steps. And then financial records, you also should maintain, make sure you have them as a subset of your official records. The secretary also typically prepares the agenda and meeting notices for each meeting. They coordinate the mailings, usually with the assistance of the manager and sometimes legal counsel. Make sure you are following all the requirements and statutes for notifying the members of any meetings. You also are the keeper of the meeting minutes and the records of votes. You can do this in coordination with management as needed. And you can also be designated as someone who signs on behalf of the association for official business. Sometimes it's just the president, sometimes the secretary is also empowered. It really just depends on how your particular association operates. Moving on, we also typically have a treasurer. The treasurer maintains the association's financial records and bank accounts. They prepare and ensure compliance with the budget as approved by the board in accordance with your governing documents. The treasurer maintains the owner ledgers and report delinquencies, making sure that they are up to date and accurate. The treasurer also monitors association bank accounts and funds, making sure that vendors are being paid on time and that funds aren't just disappearing. You also prepare the disbursement and income reports, which become a part of official records. You prepare the annual financial report and you submit financial records for audit as needed. And you approve invoices and authorize disbursement of association funds. So if you get an invoice from a contractor, say lawn maintenance, says you owe X amount of dollars, treasurer signs off on that, and then it gets dispersed, typically by management. Now, moving on, assuming that you are not a director or a board member managed association, your manager is sort of the person that handles the day-to-day issues and the day-to-day operation. They take the broader goals and vision of the board, and then they put this into day-to-day practice. The manager will have a contract with the association to manage the affairs at the direction of the board. The specific duties of the manager will be described in the contract. Sometimes the board will assign specific duties of the manager. Other times they will retain those duties for themselves. It just really depends, case-to-case basis, based on the needs of your association. The manager also administers the services, programs, and operations of the association per the contract again, in compliance with the statutes and direction from the board. They coordinate meetings, and then they can assist with preparing and sending meeting information and notices as directed by the board again. Now, a new requirement for managers, they must attend in person at least one board meeting per year, provide the name and contact information, hours of availability, and the summary of their duties that they owe to the association on the association website. This just keeps your regular members informed and up to date on exactly what the manager does, as opposed to the board. Oftentimes, the board will delegate to the manager the responsibility for keeping the minutes of association meetings and maintaining association records. The records must be maintained in an organized manner. And even if you delegate this responsibility to management, as the board, the buck stops with you, and it's your responsibility to make sure that these records are being maintained properly. Oftentimes, the manager will handle budgeting and financial responsibilities and will collect assessments, but again, under supervision and direction from the board, oftentimes the treasurer. The manager can also serve as a resource for information and training for board members. Now, you may be new to community association direction. You may be a new board member. Your manager is an important resource for making sure everything operates smoothly. If you come across a strange situation, odds are they or someone in their company have seen it before because they come to you with a wealth of experience. The manager can also serve as a go-between with some service providers as the board determines, and they keep the board informed of association business. So, like I said earlier, they are the day-to-day person on the ground. They probably have a little bit more day-to-day contact with the ordinary membership. They may hear some complaints that you don't hear. They may know little details about the operation of the association. So they're responsible for keeping you as board members informed about the day-to-day operation. Now, from time to time, you will probably shift between different management companies, whether you terminate the contract or whether your contract just expires. Your manager is responsible for making sure that you have an orderly transition to your new management company. They must transfer the records and provide them to new management within 20 days of expiration or termination of the contract. Like Michelle explained earlier, managers now must disclose any conflicts of interest to the board, and they now must have an account with the DBPR of all the associations they manage. And if their license is revoked, they cannot work in the CAM business for 10 years. So this is sort of a cooling off period if they lose their license. Moving on, some more new requirements that went into effect last July. Community association managers have to have an account listing all the associations they manage. And then management firms have to have an account listing all the managers that they employ. So you can see who works for who, and we have open information there. Again, if a CAM license is revoked, can't be in the business for 10 years. And very specific requirement for management contracts that was just put into place last year. All contracts must state in 12.5, not 10, not 14, that the community association manager shall abide by all professional standards and record-keeping requirements imposed pursuant to Part 8 of Chapter 468 Florida statutes. Now, this is something they have to do anyways, but now they have to inform you affirmatively. Managers must also, they cannot waive the professional standards by contract. So you can't have a provision in the contract, or you can't have a handshake agreement with your manager saying, hey, don't follow the law here, or let's cut some corners there. Just don't do that. Community association managers must also be fully licensed to enter into a management contract, and you as board members have the affirmative duty to make sure that they are licensed. If someone comes off the street to you and says, hey, I'm a licensed community association manager, let me work for you guys. You can't just take them at their word and say, okay, come aboard. You have the duty to investigate, make sure that they actually have a license. If you're working with a reputable company, this is probably a very simple process. But again, as board members, you are the decision makers. The buck stops with you. You have to make sure that your manager is properly licensed and is performing their duties properly under the law. Now, a management contract may be terminated upon suspension or revocation of license because they don't have a license, they can't do this job. And then finally, a community association manager may not knowingly take direction from the board in violation of any state or federal law. So they have the duty, if you tell them to do something illegal, they have to refuse to do so, but just don't do that in the first place. Moving on, the Division of Condominiums is the main oversight state agency over condominium operation. Their jurisdiction is quite broad. It includes enforcing compliance with 718, the Condominium Act. This includes financial issues, financial record keeping, and annual reporting requirements under the statute. It means that the division is responsible for making sure that you are in compliance with your governing documents, insurance and fidelity bond requirements, making sure that you are levying and collecting assessments, fines, and reserves in the proper manner, and use of debit cards, like Michelle mentioned earlier. They are tightly regulated and strictly prohibited. The use of debit cards is strictly prohibited under the statute. Why debit cards and not credit cards specifically, I don't know. There was probably some incident at some point for why they have this rule, which is why we have most rules. So just don't open a debit card in the name of the association. Just don't do that. The division also oversees the implementation and approval of annual budgets and reserves. Depending on the size of your condominium, you have certain structural reserve requirements, and those tend to change on sometimes a year-to-year basis. It's something you need to make sure that you're keeping up with. The division also oversees election and recall disputes to make sure that you are conducting elections and allowing recalls in conformance with the statute and your governing documents. They also are in charge of implementation of electronic voting, which a few years ago, the statute now allows, as long as you follow specific procedures. They also oversee official records requests and written inquiries from unit owners, which you typically have 10 days to respond to. The division may also issue subpoenas following a failure to timely comply with any requirements. Like Michelle said, we have seen a big uptick in the amount of activity that the division has been doing in enforcement and investigation proceedings. If they send you a request for information, you cannot simply ignore it. You have to comply. You have to give them the appropriate information, of course, with consultation with legal counsel. The division also oversees the operation of meetings, operation of voting, and the collection and tabulation of proxies. They also are responsible for ensuring that conflicts of interest are properly disclosed and make decisions on removal of directors if they disqualify themselves in some way. The division also administers board education requirements, such as here. So you will submit your certificate of completion to the division. And they also oversee the completion of structural integrity reserve studies and MI and other required repairs. The division also may refer persons to law enforcement for criminal violations, and this is something we have actually seen in practice. This includes attempts to impair its investigations. Say you get a request for information, you know you have some bad information in the records, you start deleting emails, you start shredding documents. They can come after you for that, and they can refer you to law enforcement for actual criminal charges. They also can refer you for if there is any evidence of fraud, theft, embezzlement, or other criminal activity. And condominium associations must have an account with the DBPR and report information as required by the division. This includes basic demographic information, such as the name of the condominium, your mailing address, your website, information on who's on the board, which banks you bank with, what the assessment amounts are currently, how many buildings you have and how old the building is, and your compliance with structural integrity reserve requirements. And then turning back over to Michelle, she's going to tell you a little bit about the governing documents of the association.
Thank you. I just want to go back to one thing that Mark mentioned about the management contract, and now it has to have this language in there that points to the professional standards that your managers have to abide by. And I wanted to kind of inform or talk about one issue that I've seen come up relatively more recently. And I think the point of adding this language to the management contract and informing board members of this is that to remember that your manager, as well as your attorneys and your accountants, their obligation is to provide advice and counsel in the best interest of the association. And so I have seen recently where board members have gotten frustrated with management and even with legal when a certain board member says, you need to do this. I told you to do this. We can't, and your manager can't do something just because one board member says, or even if the board as a whole decides it, if it's not consistent with professional obligations, statutes, or the best interest of the community as a whole. And I could give you sort of an example very recently. I had two incidents. I had one where we have a community that adopted an amendment, and the amendment was passed by the owners, and it just needed to get recorded, and you do a certificate of amendment signed by the president and secretary typically. It can be subbed out to a different officer, but president and secretary. Well, there was one board member that had advocated and worked very hard to get this amendment passed. And he was an officer, but he wasn't the president or secretary. And the president was busy and he was delaying on getting the certificate signed that could get it recorded. And he called the manager of this board member that had helped get this passed, called the manager and then called me and said, hey, I'm going to sign this certificate. You need to change it to my name because I was the one that got this passed. And if you don't do that, I'm going to get you fired. It's legitimately a conversation I had. And that is, and what I explained to him, and he, I think, finally understood, is that this is nothing, we're doing what's required by practice, which is the president and the secretary are typically your signers. It's not anything personal. And I can't just change that without some guidance from the board. So I can't act at the direction, your manager can't act the direction, and your accountants can't act the direction of one person on the board. The board is an entity and has to make decisions collectively. The other situation I had was a board member wanted to use reserves for a certain purpose, and he was encouraging, he needed a legal opinion on whether or not they could use the reserves for this purpose. And he had done his own research, and he had provided that research. And we said, well, we can't give you the opinion yet. We need a little bit more information about your reserve study, and you talk to your engineer. He said, no, I gave you all the information. I need you to render the opinion today because I have a meeting today. Well, obviously I couldn't do that, right? I need to do my due diligence to render an opinion. And again, even though this was the president of the board, your manager, your folks, they can't act at the direction of one person, and they can't act inconsistently with their professional obligation to the association as an entity. So I don't know if I hope that distinction helps. But it's just something it's recently come up, and it's been very, very interesting. And I think it's important to understand that role is guidance to the association. What is in the best interest of that community as a whole, and not just a particular board member or two. We'll have people all the time, board members are like, well, can we just have a closed meeting because we don't want to talk about this with the whole community? No, no, you need to hear from the owners. That's the point of having meetings, is that, unless it's a legitimately a legal issue where you need to get it, advice from your attorney, which can be closed, or certain personnel matters, and we'll talk about those later. Every other meeting, including any workshops to talk about the budget, you want to come up with new rules on certain issues, all of those meetings, as we'll talk about, have to be open. So those are important that you're going to get. When you get guidance, it should be, you should listen to, your managers and your other professionals, because the other thing is, and I'll tell you this, as a board, you are protected from claims of breaches of fiduciary duty and other violations. If you say, hey, I acted at the direction of my attorney or my accountant, or acted at the direction of the licensed engineer that instructed us on what we were supposed to do for this project, you can protect yourself from liability. So just an important thing I just wanted everybody to kind of be aware of. So now we'll move on to another subject, which is governing documents. So previously we talked about the statute, 718, 720, and then obviously there's 468 that applies to managers. Those apply uniformly across the state. Your governing documents apply just to your community. And there are similarities, but there are also a lot of variations. They are drafted by the developer. That is important. The developer drafts them in the interests of the entire community, and he sort of sets the playing field. But over time, things change. And so there are procedures for amending the documents that we'll talk about. Each of the documents has its own amendment process. The way you amend your declaration is different from the way you amend your bylaws, your articles, and your rules. Those are your four main documents. You got your declaration of condominium or your declaration of covenants. You have the articles of incorporation, the bylaws of the association, and the rules and regulations. All of the owners are responsible for knowing these documents. There's a new statute that you have to provide all of the owners with the documents when they first acquire their property, but they are recorded in public records. So they are basically, by recording them in public records, they are baked into the land and they apply to that property, whether it's a condominium unit, a townhouse, or a single family home. Those covenants apply to each parcel and every owner is required to abide by them. Now, the association is there to kind of help enforce, inform, and ensure compliance. But just because the association doesn't tell you, you need to trim your tree, or you need to, I think of a good example that would be, you can only have 2 pets in your unit. That's in your covenants. And when you bought your unit, you're responsible to comply with that, whether somebody tells you to or not to. So the association is just there to help enforce the obligations of the owners. You have to retain them permanently. Obviously, you have guidance on how to read them. They are very long. There's a lot of words in them. Some are like hundreds of pages. And actually, the longer ones tend to be easier to read than the shorter ones. Okay. So, and I said the homeowners association, you have to provide copies to all of your new owners, and you have to send them amendments. So if you make any amendments, those have to go to the owners as well. You can now satisfy those by posting them on the website. We'll talk about website requirements. If you're in a condo and you have 25 or more units, you are required to have a website. HOA 100 or more are required to have a website. Even if you're smaller than that, I encourage you to have a website, because you can post all of these records on your website, and it is a great way to respond to official records requests and not have too many complaints about that issue. Okay, so the declaration. So the declaration of condominium, declaration of covenants in an HOA applies to the property. We call it the constitution of the community. It essentially blankets your property. It tells you who owns what, especially very critical in a condominium. Who owns the drywall? Who owns the windows? Where is that ownership? Who owns the balcony? What about the garages? Your declaration will tell you who owns it and who maintains it. Now, I will say, not always 100% clear. Some of the language can be, well, do we, this is especially tricky in townhome communities, because townhomes kind of look like condominiums because they have adjoining walls and adjoining roofs, but they are typically, not always, but they're typically treated as, or formed as a homeowners association. So the association will have an obligation to maintain the exterior. Well, where does the exterior begin and end? I have the case where there was, the association is responsible to maintain the exterior of the property, where there were cracks in the stucco, and over time, water got in and penetrated to the interior of the unit. So unit owner, hey, association, this is all your fault. You fix it all. That's not really what your documents say. Your documents say exterior. And so it's very critical to read those documents and read them very carefully and obviously get guidance because they can be very complicated. So they'll talk about ownership, they'll talk about maintenance, use restrictions, whether or not you can lease your unit, what the term of the lease is, whether or not you can have pets, what are your maintenance obligations? Do you have an architectural control committee? What are the requirements for that architectural control committee? There'll be things in there about insurance, what type of insurance that you have. There'll be information about what other entities, SwiftMud, what roles they may have, whether you have a CDD, a community development district, that can be mentioned in there and talk about what their role is in the community. You can amend your declaration, and this is important. We see very often, as time goes on, at the very beginning when a community turns over from developer to homeowner control, there's a lot of interest, a lot of activity, and people come to the meetings, and that wanes over time. So as years go by, you get fewer and fewer people that attend, that even read the meeting notices or the minutes, and it becomes harder to amend these documents. Because some of you will have documents that you can only amend your declaration with 75% of all owners in agreement. Well, if you have a community with 500 units, it's really hard to get 75% of them just to respond, much less to all agree. So you want to look at what is your amendment process, and you can change that. You can make it 75% of the owners who cast a vote, or 50%. We've seen very different variations of that, but you want to look at that because I've seen communities that are just in a bind, especially as we've seen the changes with Airbnb and people being more concerned about leasing. At a certain point, it becomes very difficult to amend your documents to address that issue. So stay on top of that. Okay, so governing documents, articles of incorporation. So your articles of incorporation create your association as an entity. If you want it, I have actually seen conflicts in what the name of the association is between the bylaws and the articles. The articles define the name of your association. If you're in a condominium, it should say it should say condominium in the name. Doesn't always happen, but technically it should. But so your articles are filed with the state of Florida, and they basically give life to your association. They'll have some very basic information about the board, the name of the entity, the original address, things like that. And they can be changed, obviously, same thing. There's an amendment process in the articles. The bylaws also pertain to the association as a corporate entity. And your bylaws tell you how that corporate entity operates. If you want to know what I mentioned earlier, you could have 3, 7, 9 directors. That'll be in your bylaws. It may also be in your articles, and they may conflict. So just things to be aware of. But most of the information about how to operate the corporate entity is in the bylaws. So what your quorum requirements are, for your meetings, your meeting notice requirements, when your annual meeting is supposed to be. I've seen bylaws that say your annual meeting has to be on the 2nd Tuesday in March. I don't recommend that, but it is in some. But it will tell you, does it have to be in the first quarter of the year? And some will just say it has to be whenever the board decides. So that kind of detail you can find in your bylaws. It'll talk about your election process. We'll go more into elections, but if you want to know how that election process goes, do you need to have secret written ballots? Those are required in condo, not in an HOA, but your bylaws may require it. Do you need a nominating committee? These are things that we try to get away from, but they may be in your bylaws. So what else? Okay, and then there are rules and regulations. So the rules and regulations are typically adopted by the board after notice to the owners. I have seen some declarations and some bylaws that require owner approval of changes to your rules. That is very onerous, and I don't recommend it because it makes it more difficult for the board to adapt to situations. Your rules should only spring from what's in your declaration. And I'll give you an example. I had a community very recently that updated their declaration, and they told me after the fact we had proposed certain things in the declaration. They had, we'll leave those out, don't put them in there. It had to do with leasing. Like, okay, no problem. They created rules, and those things that we had put in the leasing restrictions in the amendment that they had taken out, they tried to put in the rules. Things like, if you're a corporation, you can only own 2 units in the community. Your lease term has to be for not less than a year. And I said, well, you can't do that by a rule. You can only do those things by amendment to your declaration. Your rules are just filler. If you have language in your declaration that says the board approves leases, your rules say, here's what the leasing application looks like. You need to submit it within 15 days before your lease starts. You need to provide this type of information. Your rules will say, you know, if you have pets, do they have to be on a leash? You have to pick up. Where do they have to have vaccination records? Those are the kind of things that go into your rules. It's filler to try to give a little bit more detail to your declaration. And a really good example is maintenance requirements, right? Your declaration will say the owner has to maintain their lot and their property in good condition. Well, what is good condition? In some communities, you want to be more specific. And then obviously you have your architectural guidelines that will tell you if you want to have specific paint colors for the community. I've seen specific types of mailboxes that are required, mulch colors, sod. Some are very, very specific. So that's what your rules are for. So limitations on enforceability of architectural covenants. So this is in the past couple of years, the legislature imposed some new statutes that try to limit the types of rules and restrictions that can be in the declaration or in the rules and regulations. And it's not clear to us in the legal profession whether or not these statutes are appropriate, because your declaration is a contract amongst the owners. And the legislature really shouldn't be getting in between that contract unless there's some state purpose or state interest in doing so. But in any case, they did adopt these, and we're not sure where they're going to go. But they say that the association may not prohibit installation, display, or storage on a lot or within the dwelling of any item which is not visible from the parcel's frontage or an adjacent parcel, common area, or community golf course. Turf, boats, flags, vegetable gardens, clotheslines, recreation vehicles. These are examples. So if it's in the backyard and you can't see it from a neighboring lot, and you can't see it from the common area, and you can't see it from the street, the association can't tell you that you can't have your artificial turf golf course in your backyard. It can't tell you you can't store your RV in your backyard. I don't know how you're going to get your RV back there without it being visible, but if you could do it, then it would be something that the association couldn't enforce. Now, a lot of people have gotten concerned about this statute, and they're like, well, then we can't regulate anything in the backyard. Well, that's not true, because it says installation, display, or storage. So in my opinion on this so far, and we don't have a lot of case law, so we're just working with what seems operational and understanding the wording. But you can't construct the Taj Mahal in your backyard, or a mini version of it, or you can't, people will install pools and decks and patios, And the association could still have authority over that under your architectural guidelines, because those can affect drainage and other issues. So in my view, construction is different from putting in artificial turf or storing your boat in the backyard or something like that, or putting a flag in the backyard or something. So there is still some regulation you can do in the backyard, but it's a little nuanced. So you want to look at your documents and obviously consult with your manager and your attorney. There's some issue. Another thing about the association cannot require approval of plans and specifications for HVAC type systems if they're not visible and the system is approved or recommended by the association or the architectural committee. If you deny an architectural request, you have to cite the rule or covenant that supports your denial and the aspect of the improvement which does not conform to the documents. You can't just say denied. So tell them, give them a little bit of the why. Vehicles. So the next issue is vehicles. The legislature said that your documents cannot prohibit parking a personal vehicle or a pickup truck in the driveway or any other area where the owner or guest has the right to park pursuant to local law. I have a lot of communities that prohibit parking in the roads. If you don't own the roads, you may not be able to enforce that. Parking a work vehicle in the owner's driveway. This one was very controversial. There are a lot of communities that do not allow you to have a commercial vehicle parked in your driveway. The legislature says we can't prohibit that. So that is the one that's TBD, because a lot of people are concerned and are looking to fight that. You can operate a personal vehicle on your parcel or on public roads in conformance with local law. First responder vehicles can be parked in any area where an owner or guest has a right to park, including on public roads. So I have legitimately had communities get concerned about law enforcement vehicles, saying they're a commercial vehicle, they shouldn't be parked in the driveway. My thought has always been, wouldn't you want more law enforcement vehicles parked and visible in your community? But now the legislature says they have to be allowed. So you can't prohibit an owner from inviting, hiring, or allowing entry of a contractor simply because they don't have a license. So that is in 720. I don't think it's in 718 because in condominiums, you want to be a little bit more specific about what type of contractors are working on the units, because they're so likely to affect other units if things go wrong. But if you're in an HOA and you want to have an unlicensed contractor and run that risk, apparently it is not for the association. And I will tell you this, there are some things that associations do that borders on law enforcement or on enforcement of state laws. That is not your role. The role of the board is to enforce your covenants. Like I had a community that has a gate, and they were taking driver's licenses, and they were turning people away if they had an expired driver's license. And not your role, right? All you're saying, hey, you're on the guest list, that's your name, okay, go ahead on in. So they said, well, we own the roads, aren't we liable if they're not licensed and insured and something happens? Well, you could be if you start taking on the duty to enforce that, but that's not necessarily the role of the association. So just be cognizant of that. Okay, so our next issue is hurricane protection. So this is the nice scary image of a hurricane that we all are so used to seeing, or at least we got a break for a little while. Okay, so after recent storms, we had some new legislation about hurricane protection in a condominium. Hurricane protection, shutters, impact glass, code compliant windows and doors, other code compliant hurricane protection products to protect the property. So the condominium board must adopt code compliant hurricane protection specifications. including, the type of materials, color, style, those kind of things. The declaration, any new declarations now have to state who's responsible for installing, maintaining, repairing hurricane protection. And installing hurricane protection is not a material alteration of a condominium. So if the association is responsible for the windows and you're due to replace the windows and you replace them with some hurricane code compliant and it looks different, it's different from the original, which would normally be a material alteration required of a road. It is not if you're doing it for hurricane protection. Okay. So there's a 718-3026 now says that with approval of a majority of voting interests, the board may install or require owners to install code compliant hurricane protection. So if your building doesn't already have code compliant hurricane protection, you can, the board can do it via the association, or you can require owners to do it depending on the outcome of that vote. The board may operate hurricane protection without owner permission if necessary to preserve and protect the condominium and association property. So I guess if you're out of town and there's a hurricane coming, they can close your hurricane shutters. I don't really know what other things they would be operating, but let's see. There was a lot about hurricane protection recently. The unit owners are not responsible for the cost of removing and reinstalling hurricane protection if it's necessary for the maintenance, repair, or replacement of condominium property that the association is responsible to maintain. So I had a community that had was doing some maintenance on their balconies, and they had to remove all the hurricane shutters in order to do that. And it was literally, the project was happening right as this statute was getting implemented. So before the statute, it was the owner's responsibility. After the statute, it became the association's responsibility. Let's see. If the owners are responsible, the cost of removal and reinstallation will be assessed to the unit owner. If the association is responsible, obviously it's a common expense. And if an owner already has code compliant hurricane, whatever it is, windows, and the association decides to swap out all the other windows, they can be excused from that. And the cost has to be adjusted so it doesn't affect them. There were similarly some changes in the HOA statute 720 that also require the board to adopt hurricane protection specifications for all of the improvements governed by the association. And it's important to look at doing this because if the association does not adopt specifications, then an owner may be able to make alterations on the basis that they are hurricane protection that are not necessarily consistent with other alterations in the community. So if they wanted to install, purple shutters that are hurricane compliant and you didn't already have specifications, you might have a little bit of a fight there. Okay, so yeah, because the owners cannot be prohibited from installing protection that conforms to the specifications. So if you don't have specifications, I don't know that you could stop them from installing hurricane protection. So, and then there's just some examples of what the hurricane protection is for a homeowners association: roof systems, storm shutters, reinforced garage doors, even erosion control, those kind of things. All right, so the last part about hurricane protection is the My State Florida Condominium Pilot Program. This was implemented a couple of years ago. It ran out of money really quickly, got refunded, ran out of money again, and I think they're looking to refund it again. So if you are in a condominium within 15 miles of the coastline and you're 3 or more stories, you may be eligible for this pilot program where the legislature has allocated funds for hurricane mitigation inspectors to determine what kind of mitigation measures may be needed in your community, and grants to help match the cost of certain protection that may be added for hurricanes. Like if you wanted to change out your roof, let's see, you could get up to $11 per square foot of roof, not to exceed $1,000 a unit and 50% of the project cost. I think it's a max of $175,000. So, but you can get significant funds. So if this project, if the program is refunded, which I think it should be, it's just something to look out for. Okay, now we're going to talk about meetings, board and membership meetings. I'm going to turn it over to Mark to talk to you about board meetings.
Thank you, Michelle. So meetings are where all the fun happens. You have both board and membership meetings, and I want you to pay special attention to this first line where it says board meetings occur whenever a quorum of board members gather to conduct association business. And what does this mean specifically? That means, say you have a board of 5 people. 3 of you are here today. You go out in the parking lot after we're done and you have a discussion. You say, hey, you know, Joe's yard looks pretty ugly. We need to send him a violation letter. That's technically a board meeting that you are having without giving due notice and without opening it up to the membership, because you are conducting association business and you have a quorum of membership. Now, say there are only 2 of you and you go outside and you discuss this. That is not a board meeting. You do not need to notice that. You do not need to open that up. Say there are 3 of you, but you go outside and you talk about football. You don't talk about the association at all. Perfectly fine. There has to be both a quorum present of board members and you're conducting or discussing association business specifically. Now, board meetings, they can be held in person or by video conference, but I typically recommend that you hold at least some of your board meetings in person. This helps the membership feel more engaged, but you have the option to hold them by video conference. One association that we have, they find that a very good schedule for them is they have monthly board meetings and they alternate month to month. From one month they'll have a Zoom meeting, next month they will do it in person. This keeps everyone engaged. Every other month members can come, be in person, interact with the board, ask their questions, and then it also gives some months off where you can go on vacation, still attend the meeting. Now, board meetings, except for the 2 exceptions that I'll discuss in just a minute, are open to all members after due notice is provided. And that includes architectural review committee meetings and finding committee meetings where you're making a decision on whether to allow a modification to a lot or whether to fine a member. And that includes the aggrieved owner. They're allowed to come to that meeting. This also includes all official committee meetings involving a final decision regarding the expenditure of association money. And I'm going to digress a little bit and just touch on committees for a second. Most of the time, your governing documents, they do not specifically say you have to have, say, a landscaping committee or an amenities committee. Sometimes they do, in which case you do have to have that committee. But remember that committees serve at the pleasure of the board. They are there to implement the board's objectives. And we see sometimes where you have a long-established committee, they can sort of get a bit of a power trip. They think they are in charge of more than they actually are. You want to make sure that you're not letting the tail wag the dog in those situations, and that if you have a committee that's getting a little out of control, reel them in. Anytime they're making final decisions on spending association funds, they are open just like a board meeting. Now, like I said, there are 2 exceptions for where you don't have to let regular members in. These are meetings with your legal counsel to discuss proposed or pending litigation. Now, for those meetings, what you would do is you would notice it, but you would provide on the agenda closed legal session with counsel. This also excludes meetings to discuss personnel matters. So if you're having a discussion about whether to hire or fire maybe a maintenance employee or your management company, that can also be a closed board session. Now, I know every single association has that person that has an opinion on everything and has a criticism on everything. They have the right to come to all open meetings that aren't a personnel or a legal session and speak about agenda items that are addressed at a meeting. The best way to accomplish this is either at the beginning or typically at the end of the meeting. You have an agenda item where you reserve some time for open comments from the membership. Let them come up, let them give their 2 cents, and then move on. Doesn't mean you have to do exactly what they want, but you have to listen to them and let them have some input. And sometimes an aggrieved owner, all they really want to do is give their input, feel heard, and then the problem can go away. Condos, they have some statutory minimums that are in addition to the minimums that your governing documents may provide. Condos have to meet at least quarterly, and they have to permit owners to ask questions of the board at least 4 times per year. That's accomplished easily by just having a question and answer session at the end of your quarterly meeting. On issues that affect the condo, construction and repair projects, revenues and expenses for the current fiscal year, those should be addressed at your required quarterly meeting. HOAs, they don't have this minimum quarterly requirement. However, it's probably a good guideline to follow, meet at least quarterly. But then again, if your governing documents say you have to meet monthly, you got to meet monthly. Moving on to notice of board meetings. Your regular board meetings, your quarterly or your monthly scheduled board meetings, you have to provide 48 hours posted notice. This means that you post the notice in your designated area on a community bulletin board, something like that. Post the notice saying you're having the meeting at this date and time, at this location, include the agenda and any contracts that are going to be voted on or considered at the meeting. Now, 14 days notice is required for any meetings where a special assessment will be considered, or if you are considering amendments to the rules regarding parcel use. So if you are going to discuss whether to levy a special assessment for some project in the community, or whether to institute new restrictions or requirements for lots, you have to give extra notice. It has to be 14 days notice. Now, condos, additionally, any meeting where the budget will be approved, you have to provide 14 notice for that as well. The notice should also include a copy of the budget and any supporting documentation there. Now, keep in mind that these are minimum requirements. Most of the time, your governing documents will either be silent or they'll say 48 hours and 14 days. Sometimes there will be a conflict. I have one client a little bit ago, their documents are quite old, and it says 10 days notice for any meeting to consider a special assessment. In that case, follow the statute, go with the higher number. I have another one where it says 21 days instead. In that case, follow the higher number, go with the 21 days. Most of the time, your documents are either just not going to address this, or it will mirror the statute. But if there's a conflict, go with the higher requirement. That's generally, in all matters, the safer way to go. Now, notice of board meetings. You have to simultaneously post the notice, agenda, supporting documents, and contracts to be considered, and any other materials on the website. If you're an association that's required to have a website, or if you have one voluntarily, which you probably should anyways. And this just helps with community engagement beyond the requirements of the statute. You also have to state if the meeting will be held by video conference, and if you're using Zoom or Teams, you have to include a hyperlink for people to join, call-in information, meeting ID, a password if you have one, as well as any physical location where the meeting occurs. If you decide to record your video conference meeting, you have to retain the recording for either 1 year if you prepare and approve minutes for the meeting, or permanently if there are no recorded and approved minutes. Now, this is only if you decide to record the meeting. You don't have to do that. Oftentimes, we just recommend just don't record it. So you do not have to record. But if you do, you have to preserve the recording. Now, there's other details and minutia here. See Chapter 718 for condos, Chapter 720 for HOAs, and then any other additional requirements that your declaration and bylaws may have. But these are the general outlines in most cases. Now, planning for board meetings. Make sure you have a successful meeting that's in compliance with both your governing documents and the statute, 718 or 720. You want to define the purpose of the meeting in the notice. You do this by creating an agenda, which is, a guideline, a roadmap for what you're going to discuss and decide on at the meeting. This has to include the date, time, location, virtual location, physical location, how to log in, like I said. Typically at the beginning, you will have a review and approval of the minutes from the previous meeting. This can be as simple as just one line item on the agenda. Ask the secretary or manager as appropriate. Do we have meetings or do we have minutes from the previous meeting? Approve it, move on. Typically, you'll have a treasurer report, maybe not every month, but it's good to keep the board and any members present apprised of the financial situation of the association. Any committee reports, you may have a committee representative that reports on some of the goings on of their committee, some of the initiatives and events they may be holding. And then this also goes back to the problem that I said earlier. This keeps committees in line. It's an opportunity for you to direct them and make sure that they're actually doing their job instead of taking over your job. Any action items for new business, any items that the board is to vote on, you have to include it in the agenda so that the membership is notified in advance of what you are going to be deciding on. If there are any documents or contracts that are considered, you should include this with the agenda as well as the posted notice. And make sure you invite the appropriate people with due notice. This means invite the whole membership to most meetings unless it's a closed legal session or a closed personnel session. Now, membership meetings, the other side of the coin. Typically, at a minimum, or in all cases at a minimum, you will have an annual meeting where the election is usually conducted. If the meeting is held by video conference, a quorum of the board must attend in person. So say again, you have a board of 5 people, 3 people are in person, 1 or 2 additional are there virtually, that's fine, but you have to have a minimum of 3 in person. Special meetings, as they are required for the membership. This is if your documents require amendments, approval from the membership for amendments, waiving reserves, any other items that require membership approval. Notice requirements for membership meetings. Typically, your regular membership meeting where elections do not occur require 14 days notice, unless otherwise specified in your documents. But condos have a specific election procedure that you have to follow. You have to give 2 notices for membership meetings at which elections will occur. The first notice is 60 days before the meeting. This is typically where you'll say, hey, we're having an election. There will be 5 open board positions. We are looking for candidates. Then you will have a second notice between 14 and 34 days before the meeting. Sometimes you'll have a more particular specific notice period in your documents. This is where you'll typically send out the ballot and the list of candidates that have submitted. These notices, just like board meeting notices, have to include the date, time, location, in person and virtual, and the purpose of the meeting. They must be held in person or by video conference, include the specific information to access or attend in person. Any contracts that are to be approved by the membership, in some cases, it's required. You have to include that with the notice as well as the agenda so everybody knows what's going to happen, and post it on your website as well. It's required and it increases participation. Now, quorum. Your documents may provide a quorum, but if they do not, condominiums require 50% of the membership to be present, and HOAs require 30%. Oftentimes, your documents will have a lower number. that's fine. This is one instance where you get to decide, you can decide on a lower number, say, you don't get a lot of membership participation and your documents may provide 30%. That's provided that you follow the proper amendment procedures. For condo elections, there's no quorum required, but at least 20% of owners must submit ballots. And as Michelle mentioned earlier, condo elections require a secret balloting process. HOA is a little bit different. Now, proxy voting. Members have the right to vote on issues by proxy. This is typically sent out in the meeting notice so that members can return them ahead of time, and that way they are considered present at the meeting and can instruct their proxy holder to make decisions for them at the meeting. Proxies are valid for 90 days. So if a meeting is adjourned and reconvened later or postponed by, say, a week, that proxy is still valid. If you postpone it by like 4 months, you need to issue new proxies. Condos, again, have some specific requirements. For condos, you cannot use proxies to vote for the election of directors. Now, this is different from sending out written ballots in advance that can be turned in. Those are ballots, not proxies. But in a condo, you can't designate someone to attend on your behalf and then vote at a meeting on your behalf. It's just not allowed by statute. And for condos, general proxies are not permitted. What this means is a general proxy is a proxy that says, I give this person the right to decide on any issue that comes up at the meeting. For condos, that's not allowed. You have to use what's called a limited proxy, where you say, I empower this person to represent me at the meeting, and I instruct them to vote yes or no on each issue. HOAs, general proxies are allowed, but generally, I would discourage their use. Stick to limited proxies. It just avoids confusion. Now, video conference meetings. For membership meetings, you have to have a physical location for members to attend. And this is also the physical location where a quorum of the board must be present. And then again, if you record the meetings, they have to be retained permanently or for a 1-year period if the minutes are recorded and properly approved. Moving on, election of directors. Balloting is only required where 2 or more eligible candidates submit their intent to run for a vacancy. So say you have 5 open board positions, you get 5 people that say they want to be candidates. You do not need to have an election because there's no contest there. The exception in that case would be if you are implementing or re-implementing staggered board terms where the amount of votes you get determines how long you will serve on the board. In that case, you would still have an election to determine that. But if all the directors to be elected are going to serve the same term, you get a number of candidates equal to or lower than the number of open positions. You do not actually have to have an election. Ballots have to list candidate names alphabetically. It's just a statutory requirement. And condominium association ballots, particularly, you have to follow a process that's set out in 718. Some HOAs will adopt this process or a process similar to it, but they can have a little leeway. Condos have to follow this process where there are no write-ins allowed or nominations allowed from the floor. So that means all candidates have to submit their candidacy ahead of time. This requires a secret ballot, so you can't have a voice vote from among the membership. And as of a few years ago, electronic or email ballots are now permitted. However, you have to solicit from the membership consents to vote electronically, and you must include specific statutory language, which provides that you waive the secrecy by voting by email or electronically. Now, to administer the election and count the ballots and verify that everything is on the up and up, you will assign an impartial committee of usually non-director members. For HOAs, nominations from the floor are not required if owners are permitted to nominate themselves ahead of the meeting, and floor nominations are not required by the bylaws. So if you decide to take more of a condo approach and you say you do a 2-notice system, you send out a first notice soliciting candidates, you get candidates, you do not have to allow nominations from the floor at the meeting unless your bylaws specifically say so. Election disputes must be submitted to binding arbitration with the DBPR, or they may be filed in circuit court within 60 days. That 60-day period is very important. That means if you think an election was done improperly, but you wait 90 days to submit a complaint or to prosecute, you can't do so. You waive your right to challenge an election after 60 days. This is just to ensure that after the board is established for a certain period of time, that we're not going back too far and undoing some of the good work they may have done. Condo elections may have term limits. By statute, directors cannot serve for more than 8 consecutive years when they begin their service on or after July 1st, 2018. Now, note that's consecutive. So if you serve 8 years, you take a year off and then you run again the following year, that's fine. Or if, say, you started your service in July of 2017, your 8-year counter doesn't start until July 1st, 2018. All right, so election of directors, fraudulent voting activities, which we alluded to some of these earlier. There's been new law over the last couple of years that's been implemented that establishes certain specific fraudulent voting activities, which constitute a first-degree misdemeanor criminal offense. These include preventing a member from voting as intended, fraudulently changing or attempting to change a ballot, envelope, vote, or voting certificate. As Michelle mentioned earlier, if you receive a ballot that doesn't have a candidate checked, you can't just check the box for that owner. It simply won't count in such a case. You are not allowed to menace, threaten, or use a bribe to attempt to deceive or deter a member in voting. So your association is not a mafia. Don't try to lean on members, and don't do this directly or indirectly. So you can't say, I'm going to smash your windows in if you show up to this meeting and vote. You also can't say, hey, it would be very unfortunate if something happened to your property or to you if you go and vote. You also cannot give or promise anything of value to buy or influence a member's vote. And again, using or threatening force, intimidation, or violence, or other coercion to induce or compel a member to vote or refrain from voting is not allowed, whether this is direct or indirect. Now, meeting minutes. Condos have to retain meeting minutes permanently. That may seem like a lot. So if your association is old, has been operating for 20, 30, 40 years, you are required to keep those minutes in perpetuity as long as the association exists. HOAs, you get a bit of a break. You only have to retain for 7 years, but I would recommend just retain them indefinitely, so that if you ever have to go back and reference something, there's ever a dispute whether an action occurred properly in the future, you have that information to go and reference. Meeting minutes can either be in physical minute books or more commonly in electronic files. Simple Word document detailing what happens is sufficient. And board meetings, membership meetings, and official committee meetings must all have minutes. Now, some of the things to include or how to shape your meeting minutes, you should specify the type of meeting, so board meeting or membership meeting. You should give the date, time, and place, note whether there was a virtual option to attend, and keep in mind that meeting minutes are not a transcript. You don't have a court reporter or a stenographer present that's recording every word that is spoken. This is a general record in detail of what occurs at the meeting. So you will say item X was considered, item X was debated, it was voted on 3-1 to approve. You don't need to detail the entire debate. They will note who the chairman of the meeting is. As we said earlier, this is typically the president, but it can be assigned to another director or officer. You will note whether you have or do not have a quorum present, because that will determine whether you can continue on and perform actions at the meeting. You will note whether an action is taken or not taken, whether an item is approved or unapproved. And for votes, a vote or abstention from voting on each matter voted upon for each director present at a board meeting must be recorded in the minutes. That's a specific requirement from the statutes. And then, if you have committee reports or you have extensive comments, you should also include a summary of these reports. And then I'm going to turn it back to Michelle, and she's going to talk about some of your financial duties.
Okay, so thank you, Mark. Before we dive into the very exciting topic of financial duties, I thought maybe we could take a 5 to 10 minute break, and then don't all cheer. That's exciting. So if anybody has any questions before we get started, I was gonna take questions. Or I can start talking about finance, which will be so fun and exciting.
How long do you keep records? I know minutes you keep forever for condominium. How long do you keep records?
Okay, so the question is, how long do you keep records? And the fun answer that your lawyer will give you is it depends. It depends on whether you're a condo or an HOA, and it depends on the type of record. So most records, the default rule is you have to keep them for 7 years. That's kind of the default. I think if you get bids on projects, you need to keep the bids, I want to say, for about a year. We're going to talk a little bit about records and record keeping later, but the default rule is 7 years. Nowadays, with everything being electronic, we kind of err on the side of just keep them, unless there's some reason, unless you're running out of storage or something like that.
Ballots and proxies from years ago, do you keep those? We've got some from 86.
From 86?
We've got
I think
records.
you could probably dispose of records that are more than, 15 years old, except for obviously your
Minutes.
governing documents. If you have your
Yeah.
original documents, most of them are all recorded and online now, so I don't really see a lot of originals. But if you do have original declarations, bylaws, you want to keep those, original amendments, certificates that are signed off by the board, those kind of things you want to keep pretty much permanently.
Okay.
And then we mentioned condos, your meeting minutes, you want to keep those as long as possible. And I had an issue recently where there was a conflict in the rules that were posted on the association's website and the rule that the board thought it had adopted. But it was like 10 years ago that they adopted the rule, and they didn't have minutes from the meeting, so they couldn't go back and figure out what was the rule that should have been posted. But anyway, so that's why you would err on the side of keeping your minutes, even in an HOA, as long as you can for storage purposes. But I would say voting records, more than 7 years, you wouldn't need to keep. It might be a year for either HOA or a condo that you can dispose of some of your voting records. Because you can only challenge an election within 60 days. And most of the time, you can only challenge something like an amendment to the declaration within 5 years, because there's a statute of limitations issue. So if you're keeping your records at least 7 years, you should be okay. But I would keep things like if you have building plans and permits and original drawings related to your condominium or your homeowners association common areas, I would keep those in perpetuity. But yeah, so I don't know if that
Thank
helps.
you.
But outdated contracts and things like that, I mean, you can definitely dispose of those after 7 years or so.
So you may have mentioned this, but this particular PowerPoint, there's a lot of information. Is this out there, like for us to review, or is it somewhere electronically where we could?
You want a copy of my PowerPoint?
Maybe they'll
There's
like.
a lot of valuable information in there. I should charge for that, shouldn't I?
Or a quick
No,
note.
we can send you a copy. Yeah. Yeah.
The other thing,
Yeah.
other question is, regarding the director meetings and members meetings. Those are guidelines, I mean, or are those rules for the meetings? I mean, I've seen wide variations of what you guys have suggested, as for the format and protocol, that kind of thing.
The format of the meeting, like your agenda.
Well, just a number of things. I think I've seen meetings go, according to that, and some wide variations of the way they're handled, and
Yes.
a lot of the things you mentioned, are those rules, or is that state statute, or is that guidelines, or are those a suggestion, or?
So some of the slides that Mark talked about related to meetings, like the having a purpose for your board meeting and, what we recommend putting on the agenda. Those kind of things, those are guidelines and suggestions for you. What is required and what we talked about in terms of the meeting notices, when you have to notice a meeting, what has to be in the meeting notice. Those kind of things are required either by statute and or your bylaws. So those are critical. What else? Your quorum requirement, obviously that's a bylaw requirement, but usually like your agenda items and the format of and even the minutes are not necessarily prescripted by statute. So that's a lot of that is a recommendation. So does that answer your question?
Yeah, if something isn't followed, is there recourse to say you didn't follow, this requirement or this statute is in terms of, the way the meeting should be called or the way a vote should be called, that kind of thing?
Yeah,
Okay.
there is. So let's say you realize that you had a board meeting and you did 48 hours posted notice, and you find out after the fact that you should have done 14 days notice because you were adopting a rule or a special assessment. You would just correct that by doing the 14-day notice and having the meeting again and affirming the decisions that you made in the past. So there are a lot of ways that you can correct an issue if you realize you didn't comply with the statute. It's just, there ends up being an additional cost because you have to send a meeting notice out. So obviously if you can get it right the first time, yeah, but there's no HOA police that are going to go around and arrest you, although they have criminalized a bunch of things. So, maybe we'll have HOA police one of these days. But for right now, it's mostly, just trying to make sure that the board is responsive to the owners and providing information to the owners. And yeah, you can correct those things if you realize there was an error. Like I have a lot of times, and this is important in terms of meetings. And I'm not sure if I have this in the slide anywhere, but email communication. You get a lot of questions about emails. You cannot make decisions by email. No decisions by email. I strongly recommend that you limit your communication, and this is a recommendation. The statute says no decisions by email. My guidance to you is avoid substantive discussion by email, because you should be having that discussion for the benefit of your members. And if you're having it in email, I mean, the problem is too that you could get a records request for those emails and have to produce them all in response to a records request, because if you're conducting business by email, then all of your emails become records of the association. So it can be onerous to then have to provide those if somebody asks for them. But the point of not making decisions by email is that you want your owners to know, what did the board decide? Why did they decide to spend, why did they decide to hire the roofing contractor that was, $50,000 more than the other roofing contractor, right? You want that information available to your owners, and doing that at a meeting is important. So, So just as guidance on email communication. You can use it, obviously you're going to use it to coordinate meetings, when you're gonna be there, what are gonna be the topics. You know, owners are complaining about this, or I saw that the pool pump was running 24/7, let's add this to the agenda. Right, but I all the time have people that want to make decisions by email. Can we just do it by email? 48 hours post-it notice, you can have a board meeting.
Yeah.
Questions?
I have one. So is it or is it not a requirement to record board meetings?
It is not a requirement to have a recording of a board meeting. If you do have the new rule, if you do have a video conference, if you do your meeting by Zoom, then you do need to record it. But other than video conference meetings, if you just have, like, if you meet in your clubhouse and have your, monthly board meeting with the 48 hours posted notice, you do not have to have an audio or video recording of that physical meeting. You just have your minutes.
Do you have to provide a Zoom to people that are, what we call them snowbirds, when they're not here? We have to have our board meetings available to them by Zoom.
No, if you are meeting physically in person, you are not required to also have a Zoom link. I think it's not a bad idea, because the more transparency you have, the less complaints that people, can legitimately make, right? If you say, well, I gave you a Zoom link and I met in person and I sent it out, 7 days ahead of the meeting, not 48 hours. I did all of these extra things. You can't then say, well, you didn't know that we were gonna re-roof next month because we've been talking about this. But if you have a large community of snowbirds who can't be physically present, you might want to try to find a way to facilitate their participation.
Can you only have Zoom meetings? Is it allowed to only have Zoom meetings? And if you have to record them, how long do you have to keep the recording?
So you can have meetings by Zoom. Did we touch on that? Did you go through all of the Zoom stuff? So there's a lot of new requirements as to the Zoom meetings. And it's great that the legislature is now allowed for this, but your board meetings, your membership meetings can either be in person or by video conference.
Well, I think membership meetings have to have an in-person component. Board meetings do not.
So whether you have that's right, that's another issue is, so the requirements, you can have a meeting in person or by video.
Okay.
If you meet by video, a lot of times you also have to have a physical location where the owners can go and a speakerphone or something where they can hear what's being discussed. So if you board say, I'm gonna meet by Zoom every month, I want to do my monthly meeting by Zoom. Great, fine, no problem. But you also have to have a physical location where your board members can go and then there's a speakerphone where they can hear the discussion and they can ask questions on agenda items. For your membership meetings, if you choose to do those by video conference, I don't know that you actually have to have a physical location except for the annual meeting. I think maybe special meetings too, but the annual meeting, a quorum of the board has to be present in person, even if you have your annual membership meeting by Zoom. So there was a little bit of a quirk as to why they did it that way. But
Okay.
so yeah, but you can do more there. The good thing is the legislature is moving more towards electronic meetings and electronic record keeping and websites, which should make things easier. We're just in a little bit of a transition phase. Questions? Okay, we're gonna talk about money now. All right, your financial duties. So, right, you have a fiduciary obligation to your owners because you're holding their money, the assessments that they pay, and you're managing those funds for the community. So you have to have an annual budget. And there may be some requirements in your declaration, your bylaws about your budgeting process. Your budget includes all of your expenses and all of your estimated revenues. It is a forecast, right? You're not necessarily gonna, get to the end of the year and have the exact amount of expenses or the exact amount of income as you projected. And you may have expenses come up during the year. So there is some flexibility in your financing, but you do have to have a projection, an annual budget every year of what you're anticipating in terms of expenses and what you're anticipating in terms of revenues. And of course, your assessments flow from what your budget is. Reserves. So HOAs are not required to have reserves. If you do have reserves in an HOA, they have to be established by a vote of a majority of the owners, or they have to be provided for or required per your declaration. Years ago, it was just we all understood there was reserves. It, came down from the developer over 10, 15 years. People would say, well, we've just been reserving. You reserved for these 3 items, and that's what we've been doing. And so the legislature codified the way that you create reserves in an HOA there should be a record of a vote of the owners, to create a reserve for, the pool or clubhouse or roads or drainage systems, all kinds of things that an HOA might reserve for, that are not required as they are in a condo, but you may want to do that. And then in a condo, reserves are a huge new big thing. So you have the structural integrity reserve study. If you're a condominium of 3 stories or more, you have to have this SERS study, and that will identify all of the reserves that you need for your structure, your fireproofing, your painting, your windows. There's certain items specified in the statute, and you have to have a professional engineer come out and do the SERS report, and then you need to fully fund your SERS reserve. So and that timeline ended 12/31 of 2025 was when you were required to have the SERS, and going forward, it has to be fully funded. You cannot waive or reduce funding of your SERS reserves. If it's required by your SERS, you must fund it fully. Your owners can't waive it, they can't reduce it, and you cannot use those funds for any other purpose. You can't vote on that, nothing. That's what it's for. If you're in a condo, you may have non-SERS reserves. So that would be for things like if you have roads and you have to pave the roads or the parking lot. That's not, the SERS relates mostly to your condominium building structure, but you might have a pool that's not attached to the building. You might have roads, you might have drainage systems. Those would be what we call non-SERS items, for which you still need a reserve study. But those funds, you can waive or reduce the funding. You can vote to use them for other purposes. You just need a majority vote of the owners. If an HOA has created reserves, like I said, by that vote of the owners, then those funds have to be used for the purpose for which they were reserved, unless you have a vote of the owners. And you have to fully fund them unless you have a vote of the owners. So reserves it's very good to have, hence all of the legislation about them, because it's much easier to collect that money over time than it is to do a special assessment or find other financing methods, which has happened obviously, and we all know about the tragedy in Surfside where they weren't reserving and then they had these major expenses and they just couldn't get the funds to do them. Okay, so annual budget, I already talked about waiving or reducing funding of reserves. See, your proposed and your adopted budgets are part of your records. Oh, condominiums. The new 115% rule. There's this rule in condominiums that you couldn't have a budget of more than 115% of your prior year's budget, and that the owners could, request a meeting and vote on an alternate budget. Rule is now that if the board is proposing a budget of more than 115% over the prior year, excluding certain items, which we'll get to, you have to also propose a substitute budget that excludes all discretionary expenditures. in terms of determining that 115%, you exclude required reserves, anticipated non-recurrent SERS expenses. So if it's something you have to do based on your SERS report, you can exclude those costs, and then your insurance premiums. So if you have to do this substitute budget, a majority of the owners would have to approve the substitute budget for it to go into effect. Otherwise, the board proposed budget will go into effect. So there's also in the statute a prudent investor rule. So now that you have to accumulate funds based on the SERS reserve, especially if you're in a condominium, and even in an HOA, if you're reserving, sometimes HOAs and condos will have hundreds of thousands of dollars in reserve funds and be holding those for many years. So there's some attention now on how those funds are held. And so the legislature added this prudent investor rule that the board must use their best efforts to make prudent investment decisions and invest those reserve funds in an interest-bearing account, whether that's a CD, some savings account with that bears interest or something like that, ensuring that you have your principal when you need it to fund those expenses during the term of your reserve study. So if you have a 30-year reserve study, and in 5 years you need to do painting, and that's going to cost $400,000, you can invest your other funds, but you need to have be ready to pay that $400,000 expense when it comes due. So it's a little tricky, and boards may want to consult a financial advisor if you have substantial reserves, so that you can be making good investment decisions. This was actually, somebody broached this to me a couple of months ago, and they're like, yeah, this prudent investor, rule is now applying, and boards could face liability if they're not investing those funds. And I thought, well, isn't that sort of unfair? First, you make them reserve all this with the SERS, and now you turn them into investors, which is, it's a fair amount to ask of a board that already has a lot of rules on it. But in fairness, if you are holding a substantial amount of funds, it is reasonable to be making good investment decisions, because if you're just sitting in an account, because of inflation, it's technically sort of losing money, and is that really in the best interest of your community? So if you do have a fair amount of funds in your reserves, and I have communities with, 10 or 20 or $50,000, and they'll put, the money that's not needed in the next year or two, they'll put it in a CD, it earns 4% interest, 5% interest, but you are getting a little bit of return on that. And if you have any questions about how to do that, definitely talk to your manager and talk to a financial advisor and get some guidance. So the structural integrity reserve study, I'm sure if you're in a condominium, even most people who aren't in a condominium know the word SERS, because it's been thrown about throughout the state of Florida for the past couple of years. 3 stories or more, you need to have your SERS done by the end of last year. So if you have not done it already, you are under the gun and you need to get it done ASAP. The condominium division does have oversight to ensure that they are completed timely, and there could potentially be penalties if they're not completed on time. When you get your SERS report, you do have a duty to let the owners know and to let the condominium division know that you have received the SERS, and owners can either, you can send them a copy of the SERS, or you can tell them that it's available for them to receive for free. And your website is a good place to do that. Your reserves must be based on your SERS. Your SERS has to include a funding schedule so that you maintain your cash balance above 0. And it has to take into account your funding method. So the statute was changed to allow associations to fund your SERS reserve with regular assessments, special assessments, loans, or lines of credit. If you're going to use a special assessment, a loan, or a line of credit, you need a majority vote of the owners to fund your reserve. If you have expenses, so now you have something that needs to get fixed or repaired or replaced, that's part of the SERS study. You can also fund that with a loan or a line of credit. And from my read of the statute, you do not need an owner vote for that. But keep in mind, your bylaws probably do require some membership approval of loans for the association. So there's a little bit of a potential conflict there, and I don't know which one's gonna rule, but if you need to get a loan to pay for SERS expenses, look at your bylaws, because you may need owner approval to get a loan. Okay, let's see, SERS and milestone inspection. So the milestone inspection is supposed to be done every 30 years for buildings of 3 stories or more. Sometimes more frequent, sooner than that, depending on your location relative to the coastline. But that would be, you would be advised of that by the building department for your local government. They have the obligation to tell you if you need a milestone inspection sooner than every 30 years. So if you're coming up on that 30 years, you need to get a milestone inspection, which is generally pretty similar to a SERS. But it looks at basically the structural integrity of your building at that 30-year mark. And obviously that arose from the Surfside issue. Okay, so the SERS items, I think I mentioned those: roof, structure, fireproofing, waterproofing, windows. They added that if the useful life is not ascertainable or exceeds 25 years, you only have to fund deferred maintenance and not replacement costs. You can pool reserves without a vote of the owners. You used to have to get a vote of the owners up until about, I think it was just this past year. You do not need a vote of the owners to pool reserves. Or remember, you can't pool your SERS and your non-SERS. You can pool all the SERS stuff, you can pool all the non-SERS. But there's no Venn diagram, they do not overlap. Okay, so insurance. Very important to get insurance for your property. You should have property insurance. You should have commercial general liability insurance. You should have director and officer liability insurance, and you should have a fidelity bond. That's sort of your bare minimum of 4, right? So your property damages, if there's a windstorm or a hurricane or fire, you're protecting the property that's owned by the association, whether you're a condo or an HOA. If the HOA has property, and some don't, but if you have a building or a pool or something that could get damaged in a fire or windstorm, you want to have property insurance. If you have roadways, even if you just have grassy areas, because trip and fall, you need either your property insurance or your liability insurance to address those issues. We see them all the time. Trip and falls all the time. Personal injury stuff, somebody trips on the sidewalk. It doesn't matter if you own the sidewalk, they will sue the association. So if you have sidewalks in your community and they're owned by the county, you still want to make sure you have insurance to cover you if some incident happens. Fidelity bond, the amount of your fidelity bond should equal or exceed the greatest amount of money that you anticipate having in your association account during that term. So if your insurance goes from January 1 to December 31, and by July you expect to have $400,000 in there, you need to have a fidelity bond to cover $400,000, even if every other month you're going to be at 200 or whatever. So you have to have a fidelity bond, and then you want director and officer liability insurance. So if any of you get sued, the association should provide for the defense, and they should have the insurance to also cover that cost. Cybersecurity insurance is a newer one. I think it's something that people should look at. Workers' comp insurance, you can have that on your board. Sometimes we have board members that are very active. We did actually, my partner was representing a community where one of the board members tragically fell off a roof. So in doing something related to the board, not sure what it was, but But so you want to look at maybe having workers' compensation insurance. They also have, it's like voluntary workers' compensation insurance if you're doing volunteer work, or if you're having owners do volunteer work, you want to look at those things. Get to know your insurance agent. Invite your insurance agent to your meetings. I find insurance in Florida to be one of the most complicated things. I cannot understand there is vast variation between insurance policies, what they cover and don't cover, and the exclusions to that. So you want to understand from your insurance agent, I want a policy that if anybody trips and falls anywhere within the four corners of my community, that I have insurance coverage for that. Because I'm telling you, it is very complicated. I had a case where somebody stepped on a roofing nail, and we're fighting with the insurance company to determine whether or not there's coverage for that. It was on association property, you would think, but there's exclusions and exceptions and excuses. And I won't go into detail because it's active litigation, but you want to make sure that you talk to your agent and know that you're getting covered in the way that you should be. The fidelity bond, that is required by statute. So you want to make sure you have that. And then your condominiums, your insurance amount should be based on the replacement cost for your buildings. And that should be updated every 36 months. Let's see. Oh, and promptly notify your agent if you have a claim or a potential claim. If you're when in doubt, notify your insurance agent, because there are timelines on reporting claims. Okay, financial reporting. You have an annual financial report that you need to send to your owners within 21 days of receipt or 180 days after the end of the fiscal year. You send them the report or a notice that they can obtain a copy at no charge. The type of report depends on the revenues of the association. The higher your revenues, the more stringent the report. An audited financial report is the most stringent, also the most expensive, but it is very protective of the board. So if somebody's making allegations of, not using money appropriately, or misspending, or overspending, or missing funds, or something like that, if you have an audit every year or a few years, you can say there's no problem. We had an independent auditor come in and audit our books, and they're clean. So, and here's a copy of the audit, and you can read it yourself. So that is protective of the board, even if it's not required. You can go, and do this higher level of financial reporting. If you're required to have an audit, if you have annual revenues of more than $500,000 a year, and you're required to have an audit, it is possible to waive that and have a review or a compilation. And the reason that people do that is because it's less expensive. The audit is the most expensive. So you can do that. You can't do it in consecutive years. And you need a majority of all owners to approve it. Let's see. So, and then there are certain disclosures in a condominium regarding changes in your reserve accounts. Your official records now include all of your invoices and receipts and all of your bank statements, which that was updated to that. You should, any business of the association, any records of the association, you want to err on the side of keeping that as part of your official records. When in doubt, ask your manager or your employer. Okay, assessments. That's every owner's favorite part. How much is my assessment going to be, and why are you asking me to pay a specialist? Okay, so the assessments are the owner's proportionate share of the budget. That usually there's information in your declaration as to the proportion. It could be equal, it could be based on the size of the unit, things like that. But that should be set forth in your declaration. So the board will determine the budget, the amount of the assessment, the payment schedule. In a condominium, it has to be not less than quarterly. In an HOA, you can have an annual assessment, you can have monthly assessment. That's determined by the board unless your declaration has some specific language in it. You have a lien on all the property to secure payment of your assessments. That should be in your declaration, it's in statute. I had one HOA where it was not in their declaration, they could not lien. So liening is very important because people will be more likely to pay their assessments if there's a threat they could lose their property if they don't. Lien, that lien right is a very powerful right. And in order to exercise that right, you have got to abide by all of the rules of the statute. So the statute says that you have to send your owner a notice of late assessment if they have not paid on time, before you can even send it to the attorney. So I don't know anybody that wasn't already sending late notices, but apparently there were communities that weren't sending late notices before sending owners to the attorney, or at least there were owners complaining that they weren't getting notices. But anyway, so you have to send a notice of late assessment, giving them 30 days to pay, and then you can send it to an attorney for collections if they don't pay in the 30 days. And then we've got to send them a notice of intent to lien before we record the lien, and then another notice of intent to foreclose that lien before a lawsuit can be filed. So there's a time delay between when an owner becomes delinquent and when you can file legal action and file a lawsuit. And if you're in a condominium, and some condominiums, the monthly assessment is $800 a month or more. If you have special assessments, people can be, $5,000 to $10,000 behind in assessments within a few months. So you want to stay on top of that. The greater that receivable gets, the harder it is to collect the whole thing. Because oftentimes if somebody's delinquent in their assessments, they're also delinquent in their mortgage, and you may have to compete with the mortgage company to enforce your lien right? Because you can only sell the property so many times. If there is a mortgage foreclosure by the bank and the bank forecloses and sells the property, that could eradicate your lien, and the association would only, if the bank buys it or an assignee of the bank buys the property at a foreclosure sale, the association only gets 1 year of assessments or 1% of the principal balance of the mortgage, whichever is less. If a non-interested person, if it's not the bank and it's not an assignee of the bank, it's just some third-party buyer, they may still be responsible for all of the assessments that accrued prior to the mortgage foreclosure sale.
Yes,
Sure.
yeah, I have a question.
Okay.
Management company, takes care of your finances with late assessments collecting. Whose responsibility is it, to do these letters? Is it the board, is it our responsibility, or is it the management companies? Because they're gonna charge the association part of that $25 late fee that they're charging.
So the answer is it depends. That is not prescribed by statute or your documents. The statute says you have to send a notice of late assessment 30 days before you send it to a lawyer and incur legal fees. Whether the secretary of the association sends out the notice of late assessment or the management company does, that is between the association and the management, and that would be dictated by your contract. So your contract with the management company would say what notices and how they do that, what they charge for it, and you can negotiate those issues. Oh, more questions. See, everybody's favorite topic.
On the assessment, is there anything stipulated on how much time if they do a special assessment? Do they have to give you a certain amount? Because we were given like 6 weeks.
Understood. So the question is, if the board imposes a special assessment, are there any requirements as to how much time owners have to be given to pay the assessment? Typically, no. Your special assessment will either be imposed by the board, or it'll be by the board with some vote of the owners. That is going to be in your declaration. Some declarations say you have to get owner approval of a special assessment. A lot of them do not. And I mentioned a couple of things with the surge, where if you're going to do a special assessment for the surge, you might have to get owner approval for that.
Like 20.
Usually, the board, unless there's some specific requirement for member approval, the board would approve a special assessment. They would approve the amount, the due date, and whether there's gonna be some sort of installment plan. Like, so you could have a $10,000 special assessment and tell owners, they have 6 months to pay or something to that effect. Or you could say, I'm passing a $10,000 special assessment, it's due July 1. And that's up to the board, and it will depend on the need, right? If you need the funds right away because you're doing a roofing project and you need to pay the roofing contractor, or you got a loan and you need to repay that loan, you need to make sure you're collecting those assessments in time to address the issue. And sometimes you'll have urgent issues that come up that require, immediate financing. And so that special assessment is a very good tool for that. And the time frame for payment is dependent on, what the nature of the reason for that special assessment is. Some, and as I said, some special assessments will require owner approval.
So, like with us, it was 20,000 in 6 weeks due to the surge. But they didn't use, they used the first half of that 6 months later. And then 6 months later, they started working on the second half. But they collected it all within 6 weeks. And it put a lot of hardship on everybody. And there's nothing we can,
So-
you're talking about doing it maybe again.
So special assessments are, as I mentioned before, can be very challenging on owners, and that's why we want to reserve over time to avoid having to do that. In terms of, what's required for your SERS, if you have a structural integrity reserve study and you have to collect X numbers and you have to fully fund it by according to the legislature, and then you have certain things that you have to do, right? Your reserve study says you have to do painting, or your reserve study says you have to replace your roof, or whatever it is, you got to incur those expenditures, and it can be challenging. It can be onerous on owners. That we have 100% seen that, and how the board handles that. That depends on a lot of circumstances. It depends on what your need is, how much money you have, how many owners you have, how quickly can you get the money, can you get a loan? There's all kinds of things to consider, so I can't give you like any kind of specific guidance, but that's certainly something you want to talk to your manager, your reserve study person, and your lawyers about. There's one other question, and then I'll.
So it's regarding the foreclosure. We have a situation where an owner passed away with 2 mortgages. They're in foreclosure. We're waiting on assessments. It's definitely been more than a year. So are you saying that if there's enough funds, we still would only get 1 year? I didn't quite understand.
So what I was saying was, if a bank forecloses on a unit in your community, and there are past due assessments that are owed to the association, whatever that amount is, the association, if the bank forecloses and the bank takes title, that's the simplest, but there's a little exceptions, but the simplest is the bank, but we'll use Bank of America. Hope everybody loves Bank of America, whatever. Bank of America forecloses on John Smith. John Smith is behind in assessments to the association by $5,000. The bank forecloses. They have a foreclosure sale. The property is sold. It is bought by Bank of America because no other bank or no other person bid on the property. The bank takes title and owns that property. The bank then owes the association 1% of the principal balance of the mortgage or 1 year of assessments, whichever is less.
Okay.
Now, there can be all kinds of issues, and I can't get into specifics as to, multiple mortgages and whether somebody's deceased, but those are different nuances, and there's, a lot to talk about there. But for a mortgage foreclosure action, if the bank forecloses and the bank or assignee takes title, then that's going to limit the recovery of the association.
But if it's sold to a private person,
That private person is typically responsible for the full amount. So again, there's nuances to everything. The lesson for the association, the board here though, is stay on top of your receivables. If somebody is behind for a couple of months, 1 month, 2 months, 3 months, depending a little bit on what your assessment is, right? If you have an annual assessment, and they're, you know, a 1 month behind, you might want to give them a little bit more time. But if you're in a monthly assessment and you're in a condo association and you have assessments of $300, $400, $500 a month, if somebody's 30 days behind, you may want to go ahead and send that notice of late assessment. That's just like, hey, guys, send your money in, because, you know, you can't delay on that. And owners, you know, sometimes they get into circumstances and it can become challenging. I strongly recommend that you have a policy of when you're going to send that notice of late assessment. So if you're on annual assessments and you want to give them 3 months, fine, give them 3 months. If you're on monthly assessments and you want to wait 2 months, you do that. You do it on the first month, up to you. But just decide what that's going to be and follow it. Because I can tell you, you're going to have circumstances where the owner is going to call you and say, hey, I lost my job. My spouse is having serious medical issues. My so-and-so passed away. I've been in the hospital. I mean, we have heard the gamut of all these things, and some of them are truly, it's hard, right? And it's hard not to get caught up in that, but your obligation is to collect the assessments for the benefit of the owners. Because if owner A is not paying their assessments, everybody else has to kind of pick up the cost of that, because you still have your expenses, right? You still have to pay your electric bill. You still have to maintain your property. You still have to fund your servers. And, you know, so just have the policy and stick to it. We do hear a lot of reasons that people are behind on assessments. Some are clearly genuine. Some don't seem to be, and it's really hard to verify that. And if you make decisions to give one person a break, then you have to figure out if you're not going to give the other person a break, you know, like, so it becomes a little bit of a slippery slope. So have the policy and stick to it. There are a couple other ways to enforce non-collection or past due assessments. You can suspend right to use the common areas. They haven't paid their assessments, they don't get to use the pool. You can also suspend voting rights in certain circumstances. I talked about mortgage foreclosures. Bankruptcy, owners will file for bankruptcy if they're behind in their assessments, and for whatever reason, if they file for bankruptcy, that stops the collection action. There's called an automatic stay in the bankruptcy, and you can still pursue collections, but you have to do it through the bankruptcy court and through the bankruptcy plan. So it will slow things down, but you should still be able to recover the amount that's due to the association. People always complain about lack of notice. Always. I have to send people, sometimes I'll send people, I'm like, well, we sent you these 4 letters. I didn't get them.
Yeah.
You're like, is this your address? That's my address. Like, I don't know what to tell you. There's a rule in Florida that we call it the post mailbox rule. If it's placed in the U.S. Postal Service, it's deemed to have been received within a reasonable amount of time, unless it's actually returned by the post office. So if somebody says, oh, I didn't get that, and it's sent to their address or their mailing address as they provided to the association. So don't change somebody's mailing address or address because you heard that they moved or you heard that they bought another property. You only change it if they give you written notice. If they want their mail to go somewhere other than the property, you should have something in writing from them. So violations, we'll talk about. So violations, these are non-monetary violations. These are the people that don't follow the rules. They have too many pets. They didn't submit their lease application. They're not maintaining their property. They painted their mailbox the wrong color. All of those things. Policy for enforcement. How many notices are you going to give them? I have some communities that want to send out 3 violation notices before they take any other enforcement action. Some are like 1 and done. It depends on your community and how you want to do that. Do you want to impose fines? If you're going to impose fines, you have to have a fining committee. In a condominium association, your fines cannot become a lien on the property. So if you have $10,000 in fines on some condominium unit owner, but they're paying their monthly assessment, those fines just sit on their books. We cannot foreclose for that. You can in an HOA. So if you have an HOA, if you have a fine of $1,000 or more, but your fine can't be more than $1,000, so $1,000 is the sweet spot. If you have a fine of $1,000, you can lien and foreclose for non-payment of that. So it does encourage people to comply with the rules. So you have the option to fine, but you have to have a fining committee and you have to have a hearing and you have to give the owner notice. And if you don't go through all those steps, your fine will not be enforceable. If the owner corrects the violation before the fining committee hearing, you cannot impose the fine. One other distinction, the fine is imposed by the board. So you have a fining committee, but the fining committee is not setting the fines. The fining committee is not saying, oh, they didn't fix their mailbox or they didn't replace their roof or pressure wash their sidewalks. So we fining committee are deciding to impose a $1,000 fine. That's the board's job. Board imposes the fine. And then you have a fining committee hearing, and the fining committee can either uphold or reject the fine. So let's say you have an owner, they failed on some sort of maintenance requirement for their property, the grass hasn't been trimmed in years, they need to pressure wash the driveway, you've sent notices, they didn't. So the board says, yeah, we're gonna fine them $1,000. Fining committee hearing, 14 days notice. They go to the fining committee, they haven't fixed the violations, but they appear and they say, hey, I am in the military, I've been deployed, I literally just got back 3 days ago. Can you give me, I will get this done. Here's my plans to get it all fixed. And the fining committee can say, okay, great. Well, then we will not impose this fine. That's a reasonable explanation and we're not gonna, so that they do have some leeway. They can't change the fine amount. They can't say, oh, well, okay, we'll knock it down to $200. Can't do that. Uphold or reject.
What if you don't have the committee?
You cannot fine. If you don't have the committee, you cannot impose fines. Because they have the right to that hearing. Even if they don't come, they have the right to the hearing. So you have a hearing anyway. If they show up, they can plead their case. If they don't show up, you still have the hearing and the fining committee makes a ruling. I'm gonna take.
If they damaged our building and we have to fix it, the association's paying dollars to a contractor to fix it?
Okay, two different issues.
Okay.
Let me, and I want to get through some of this and then we'll take some more questions towards the end. I know you guys have great questions, but I kind of want to help us get through this because it is a little bit long. So let me finish out a couple more and then I'll take some questions. One other thing that I was going to mention in terms of enforcement, if somebody's not, and this usually comes with maintaining your property, somebody's not maintaining their property, most declarations, particularly in an HOA, have a right of abatement, which means that the association can go on the property and they can do the pressure washing and they can assess the cost to the owner. There was some recent case law that said that if you had a right of abatement, you must exercise that before you can file a lawsuit against the owner for an injunction, which is kind of a big deal if the issue is like roof replacement. If somebody hasn't maintained their roof and their shingles are falling off and you've sent a violation notices and they haven't replaced the roof, even though you have a right of abatement, can the association really go in and replace somebody's roof without, I don't even know if they can pull the permits to do that. But this case kind of indicated that the association would need to go ahead and do that roof replacement before they tried to file a lawsuit to get the court to order the owner to do the roof replacement. There's now some conflicting case law and hopefully the Florida Supreme Court will come up with the right decision. You all can guess what I think is the right decision. We're very cautious about using the right of abatement because we are in a stand your ground state, and even though you may have a right to enter somebody's property, they get very upset about that. We can't bring you back to life because you have a right to be there. So you want to be very cautious about using a right of abatement. It works well with abandoned properties. There are times when it works and there are times when it's not appropriate. So, but you do have that, it is an option. If somebody damages common area property, usually have a right to assess the owner to recover the cost to repair damage to common area. And then I wanted to mention towing. Be careful about towing. You should, if you have the right to tow, it should be in your declaration, particularly in an HOA. If you do not want to tow from the owner's property. So even though my declaration may say, no RVs may be parked in the driveway, and any violation of these parking rules could result in towing. We do not recommend towing from the owner's driveway. Use one of your other enforcement methodologies, but you should only tow. And this is a conservative recommendation, making different recommendations from other attorneys. This is conservative because towing is high liability. People get very mad when their car is missing. So you want to make sure you have the right to do that. So we only recommend towing from association property. They parked on the grass, they're, parked in the parking lot for, weeks and weeks at a time, things like that. The unlicensed vehicles parked in parking lots, whatever, but as long as it's association property. Okay, so enforcing the rules and regulations. I talked about this. There's some specifics in the statute about the fining process. I mentioned the 14 days notice. There's timelines for sending owners the notice if their fine's been upheld. I won't go through those, but just know if you're fining somebody, you need to make sure that you're following the statutory process and your governing documents. And so you want to consult with your manager and your attorney to make sure you're meeting all those requirements. So our next topic is official records. And I'm going to let Mark take that one for you, and he's going to talk about what are official records and back to that question of what you need to maintain and how long.
All right, official records. So as you're probably aware, owners have the right to inspect and copy the official records maintained by the association, or the owner's designee has the right to do that. A lot of times that'll be an attorney that the owner identifies. Now, the language is specifically inspect and copy. That means you can, but you don't have to say, email them copies of the official records they ask for. It means that you have to give them the opportunity to come in, inspect, look at the records, and make copies. If you find that it's easier to email, you're allowed to do that. Also, for those records that you maintain on your website, you can simply point the owner to that. If they ask, can I inspect and copy the declaration? Yes, that's an official record. Yes, they have that right, but you should be keeping that on the website anyways. You can just point them to the website, say it's on there. There you go. Now, the statutes are very specific about what constitutes an official record of the association. We have the list up right here. This includes the deeds and property records for association property and common areas, the original declaration, bylaws, articles, rules and regulations, and all amendments to those. For condos, you have to retain those permanently, but as Michelle discussed earlier, a lot of times these are recorded in the official record, in the official records of the county, and you could pull copies of that if for some reason your current records are deficient. You also have to maintain minute books, but these can be electronic, it can just be in a PDF or a Word document if you're not taking handwritten minutes, which was the case. We're not doing that anymore. Video recordings of meetings to the extent that you have them. Voting records and proxies, these have to be retained for 1 year from an election. The financial and accounting records, this was recently expanded to include any invoices and receipts received by the association. As you can imagine, that might be a lot. So every time a lawn service or maintenance is performed and you're billed for it, that bill or that invoice is an official record of the association. You have to maintain it. Also includes deposit slips and bank statements. Also, any building permits acquired by the association for any work that you might do on association property. Any records inspection checklists that are produced. We're going to talk about that in a minute, but you have to compile a checklist for any records inspection that takes place, and those checklists themselves become official records. Board certification and education records, so proof that you attended this class, the certificate you received today, that's an official record of the association. Any contracts, leases, or management agreements that the association enters into. Any bids for contracts have to be kept for a year. Insurance policies, proof of insurance, any warranties, permits, plans, warranties, or other items required by the developer. For condos, these developer items have to be retained permanently. The roster of owners and mailing addresses is an official record. Now, there are some things that might be included on the roster of owners that could be considered confidential and that you may redact if the roster is requested, but we'll get to that in a minute. Documents required by statute. So the Q&A that 718 requires, any inspection reports, so any SIRS studies, those are official records. You have to maintain that. Required affidavits. So most commonly, affidavit of mailing that is required for any notice that you send out. That's an official record you have to retain. And any owner that wants to see it, you got to let them see it. Now, unless otherwise provided for a specific record, HOA records, you have to keep for 7 years. Condo records have to be kept permanently unless specified earlier, such as like voting records, it's 1 year, contract bids are 1 year, but everything else, you should hang on to that. It's just another instance in the statutes where they have a little bit more that condos have to do. Now, condos must also have some of these things on hand, ready to hand out. This includes hard copies of governing documents, amendments to the governing documents, the Q&A sheet, annual financial statements, and the annual budget. Just be prepared to give these out to owners. If you're an HOA, you can just point to the website. Now, official records, they talk about the requests and the requesting process. If you receive a written request, keyword written, for official records, you have to provide either the records or an opportunity to inspect and copy the records within 10 business days of the request. This is a pretty hard line in the statute, and there can be some fairly severe penalties for not conforming with this in some circumstances. You also now have to provide a checklist of what was and was not provided. Sometimes a record simply doesn't exist, whether it's something that you were supposed to maintain, but for whatever reason, maybe 5 years ago, a different board wasn't maintaining the records properly, or it's just not a record that exists. It never existed. You just have to identify that on the checklist. If that's something that the owner requested, just identify that this doesn't exist or we don't have it, because you can't provide what you don't have at the end of the day. Records must be maintained in an organized manner to facilitate owner inspection. A lot of times this is just keeping orderly electronic documentation of everything. And you have to make a good faith effort to recover anything that's missing, lost, or destroyed. But if you make the good faith effort and then you determine that this just doesn't exist or it's just gone for whatever reason, you obviously can't provide what you don't have. Now, renters may inspect and copy some of these, and that includes the declaration, bylaws, rules, any amendments to these. And you can impose reasonable rules for inspection and copying, but one thing you cannot require is you cannot require a member to give a purpose or reason for inspecting the records. If they say, we want to see the roster of unit owners, you can't ask them why. You just have to let them do it. And like I said, to the extent that you have official records on the website, you can just direct them to the website. They ask for the declaration, say it's on there, go look.
Excuse me. What was the first thing you said?
The first thing
No,
on this slide,
no. When you said we can't ask them why.
you cannot require a purpose for the inspection.
What? Say that whole sentence again.
Sure. So if someone comes to you with a request, a written request to inspect and copy official records of the association, you have to just let them do it. You cannot ask why, and you cannot require a reason for inspecting the records. They have the right to do that for whatever reason. And then moving on, as I mentioned earlier, there are some parts of official records or some records themselves that are considered confidential and which you do not have to provide and which you shouldn't provide. These include attorney-client privileged communications, personnel records, so, records pertaining to any personnel employed by the association, medical records. Most of the time you probably wouldn't have this, but if you do not have to provide them. Electronic security passwords. You do not need to give your email passwords to any owners. Software and operating system access information, same with passwords. Protected member information. This usually comes up if this information is included in a roster of owners. You can redact this specific information if the roster or some other document that contains any of this is requested. This includes social security numbers, driver's license numbers, credit cards, email addresses, fax numbers, emergency contact info, other addresses, and personal information. Also, confidential is information obtained in a gated community in connection with guests' visits to parcel owners that are part of the official records. You don't have to provide the guest information. Now, non-protected information, go into the member information. Their names are not protected. Their unit numbers are not protected. Their mailing address, not other addresses, but their official mailing address is not protected. Their unit or lot property address, not protected. Telephone number and emails and fax info that's provided to receive notices. Now, if they don't consent to receiving electronic notices and you have an owner's email, that is protected. If they do consent to receiving notices and you have an owner's email, it has to be provided. Emails may be used for association business purposes only. You can't, as a board, give these out to vendors or sell them to third parties. I hope you wouldn't do that anyways. Now, owners' affirmative acknowledgement of a change in the method of delivery of notices regarding assessments is part of the official records, but not subject to inspection and copying by unit owners. That's a little bit of a very specific niche situation, but it's another exception to something that is an official record, but owners aren't entitled to copy and look at. Now, official records as far as violations go. There are a lot of pitfalls in the statutes that can get you in trouble if you do not properly provide access to official records. Most of these have an intent requirement, but we have seen some of these enforced. First of all, the knowing and willful failure to disclose records according to 718 or 720, or to destroy accounting records may constitute a misdemeanor, or if this is done in connection to avoid detection or punishment for a crime, it can be considered a felony. Any director, member, or manager who knowingly and willfully or intentionally violates record inspection laws with the intent of causing harm to the association or to a member commits a misdemeanor in the second degree. Now, you may think, how could you prove intent here? And I would agree, that's a high bar. But I will say, charges for this have been brought against board members for failure to provide official records. That's still ongoing. Not sure how that's going to be resolved, but that's something to keep in mind, that these are not empty threats. These are real consequences that could come into play if you don't properly follow these rules. Additionally, any person who knowingly or intentionally defaces or destroys accounting records, or who knowingly or intentionally fails to create or maintain accounting records with the intent of causing harm to the association, commits a misdemeanor in the first degree. You are subject to a civil penalty and you are automatically removed from office. The willful and knowing refusal to produce records with an intent to avoid or escape detection, arrest, trial, or punishment for a crime, or to assist another person to do so, constitutes a third-degree felony and requires immediate removal from the office. So any destruction or refusal to produce a record in order to avoid the uncovering of a crime for you or anybody else, that it becomes a felony at that point. Now, the association's website or mobile app, we've talked about this a little bit already, but some circumstances you're required to maintain a website or an app, but we would suggest that everybody do it anyways. Condos are required to do it if you have 25 or more units, and HOAs must have a website when they have 100 or more lots. Again, it's probably best practice. It's 2026, maintain a website. It saves you some grief as well. It helps you be able to point towards some of the governing documents without having to go through the whole inspection and copying process. It helps with owner engagement. And it makes them feel more connected to the community and just keeps people happy. As we said, associations can fulfill requests by directing them to the website if that record is there. You have to have an owner-only accessible page on your website, and new documents that have to be posted within 30 days. So if you have an amendment to your declaration, you should post it to the website within 30 days of that amendment taking effect. Meeting notices, records, and documents must also be posted to the website. This includes the governing documents with amendments, declaration, bylaws, articles of incorporation, any other rules and regulations adopted by the association. The management agreement you have with your management company also has to be there and be available for owners. Summaries. Now, the summaries of the bids for materials, equipment, or services for the prior year. The bids themselves have to be retained. Summaries of the bids have to be additionally posted on the website. You also have to post the annual budget and any proposed budget, any financial reports, certifications of directors. So what you receive today, should put it on your website. Any contracts and documents involving an interested director or manager or management firm also has to be posted. So if you, as we discussed a couple hours ago, if you go through the process of disclosing a conflict, whether you're a board member or manager, and you follow the proper procedures to sign that contract anyways, that contract and any associated documents have to go on the website. Notices and agenda for membership meetings should be posted on the website, like we said. Follow the same timelines for producing mail and posting notice. Board meeting notices, agendas, and contracts, anything that you are required to post, you should also put on the website. Bids received with 1 year should be posted. Any insurance policies, other proof of insurance, posted on your website. Current contracts that are currently in effect have to be posted. Other contracts you have to maintain as official records, but the ones that are current and in effect, you also have to put on the website. Any board meeting minutes for the previous year and any video recordings that you may have. And then I think Michelle is going to close us out with some discussion of miscellaneous issues.
Yes, don't be disappointed, we're almost done. There's just one key thing with the official records. If you have a management company, they are going to handle this for you. They're going to maintain your official records. They're going to make sure that you're compliant with the statute. You just want to kind of, communicate with them and make sure that you understand what official records you have and how they're maintained, making sure they're uploaded timely to the website, or if they're maintained in some other fashion. But if you have a management company, that should be something that they can assist you with. So don't stress. There are a lot of requirements, but as long as they're handling that for you, they're going to have it all up there and not to worry. So let me finish. I got a couple more slides and we can take some questions. So this slide is about our miscellaneous regulations. So we've talked about mostly 718 and 720 and some other statutes. These are some additional regulations that apply to condominiums and HOAs. One is the Fair Housing Act. The Americans with Disabilities Act and the Fair Housing Act are kind of sister acts. And the ADA, though, applies to places of public accommodation, which is typically not your condominium or your HOA, because those are private. There, you have to be an owner and a member to have access to the facilities. But those are governed by the Fair Housing Act, which does apply. And so if somebody has a disability and requests an accommodation from a rule, they have to, there are certain requirements that they have to meet, but you may have to allow that accommodation from the rule. And it can be all kinds of things like parking spaces, if they want to be, their parking space to be moved so it's closer to their unit because they have a physical disability. Obviously, people have heard about the emotional support animals. People will ask for, chair lifts in pools, ramps, all kinds of things. So you may have to grant the accommodation from the rules or a modification if they have a disability and a disability-related need for the accommodation. So there are some things that they have to show. I recently had an owner just last night, we reviewed this issue where an owner was they're in a condominium and their balcony it's slats. So it's kind of open, so things could potentially fall through from the upper balcony to the lower person's balcony. And so this person installed a roofing on the balcony and said, well, I have a disability and I need to be able to use my balcony because that's important for me and my recovery. Okay, and they didn't want to slip on things, but so there wasn't really a disability related need for the accommodation. It was more of a preference. There are other times where you may have an actual disability related need, and that does come up in the emotional support animal context. People do abuse that emotional support animal regulation all the time. There are plenty of online ways that you can get an online certificate that says that you have a disability and you're being prescribed a pet. I had one where for two renters. I hate to laugh about this, but it's a little funny. There's two renters in a condominium and they had 5 ferrets. And ferrets are not permitted in the governing documents. We only have dogs or cats, but they had 5 ferrets and they were able to get a certificate from some medical professional that said one of them needed 2 of the ferrets because of their disability and the other one needed 3 ferrets because of their disability. And we actually, a lot of times, we don't push back too hard on these things. You as a board have done your due diligence. If you've asked them to provide a letter from a medical provider and it seems reasonably legitimate, it's not your job to vet out false information. But in this case, it really just didn't ring true because, it just didn't. So we pushed back a little bit and they filed a fair housing action complaint and we did prevail. But unfortunately, this is something to keep in mind. The Fair Housing Act issues, even if you prevail on them, you can't recover attorney's fees. So if somebody files a Fair Housing Act complaint, it could be a cost to your community, even if you're in the right. So you want to be extremely cautious about those. And obviously it's more problematic if you're not in the right. So be careful about those things. A couple other things, FCC regulates satellite dishes. So owners are permitted to have satellite dishes within the FCC requirements that has to do with size and location. They can't put them in the common elements, so they can't drill a hole in the wall of condominium building, but they may be able to put it on a planter on the balcony or something like that. So something to be aware of. If you have roads, and everybody wants to have a golf cart, there is a new rule for public streets that it used to be, I think you only had to be 14. Now you have to be 18 or have a valid driver's license to operate a golf cart on a public road. We typically recommend that associations adopt a similar rule if you have private roadways. And then milestone inspection, I talked about that already. It's a structural inspection of a condominium at 30 years of age. If the building is 3 or more stories, you may have it sooner if it's required by the local enforcement agency. Energy conservation and renewable resources. Clotheslines are permitted by statute. So you cannot prohibit clotheslines. Solar collectors, solar panels, also protected by statute. You can recommend locations for the solar panels, but you cannot mandate it. It has to do something with where they get the most lighting and it's most efficient. Obviously that only applies to HOAs. You can't put solar panels on a condominium building roof. So that's a separate issue. Electric vehicle charging stations. This is becoming more popular. People are putting in their charging station and or they're plugging in, or actually they're not just putting in their charging station, they're driving their vehicle up, parking in their condominium parking space and plugging it into the association's outlet. That they can't do. So they're allowed to have an electric vehicle charging station, but the owner is responsible for the cost of installation of that station, the electric, the insurance, and those kind of things. So we've had many cases recently of owners trying to plug in, really to use the building electric, and they should not be able to do that because that's a substantial cost. So there has to be a way to apportion the cost of that electric to the owner, and it should be, the best way I know to do that is separate metering, but it is expensive. That's how it is. So you as a condominium board, though, could look at meeting with solar providers or electric vehicle, whoever, provides these products, charging stations, and say, what is the best, what can you recommend for our community? We only have 5% that have electric vehicles, but it's growing. How can we adapt to this and see what they recommend in terms of putting in charging stations, how to be most cost effective about it, that kind of thing. But it's growing in popularity. Association options for conserving resources. So, associations could consider installing things like solar collectors, Florida-friendly landscaping, obviously these charging stations, using more email and websites as opposed to paper, to do a little bit of energy conservation within the community. And 2 more issues real quick. Turnover. Probably most of you folks are not in the turnover range, but turnover happens when control of the association turns over from the developer to the owners. That means a majority of the board seats are elected by the owners. The developer can usually retain up to, I think it's 1 seat or a percentage of seats, as long as they have some units in the community, but the owners have a majority. And then the other important issue is at that time of turnover, which happens at a meeting, I actually did a turnover meeting last night. So that you have that meeting, the owners get elected to the majority of the seats. And at that point, in a condominium, the developer is obligated to provide you an audit and a turnover study and a structural integrity reserve study within 90 days of the turnover date. And then you can evaluate those and evaluate whether there's any issues or potential claims against the developer. You have several years to pursue those claims, different statute of limitations depending on the type of claim. But just to know that the date of the turnover is the date that the statute of limitations starts. So it's not that you turn over and the developer's gone and you're done with them. They continue to have some obligations to the community. And then the last issue is for HOAs. So condos don't need to worry about this, but the Marketable Record Title Act. So any covenants that apply to property in the state of Florida, they sunset after 30 years if they're not preserved by the property owner. This applies to all property in the state of Florida, and it was discovered at a certain point that this was causing HOA covenants to lapse. So the legislature created a way for HOAs to preserve your covenants. So before the 30 years runs, 30 years from the date that your original declaration was recorded, if you preserve the covenants, and all you have to do is have a board meeting to approve a notice of preservation that then gets recorded in the public records. That will preserve your covenants for another 30 years. If you miss the 30-year mark, that means your covenants have lapsed and you cannot enforce them. So you don't have enforcement rights for collecting assessments, for enforcing violations, for enforcing maintenance. Do not let them lapse. HOAs, your condo, you can ignore me. You can revitalize them after the 30 years, but it's a much more difficult process. And you have to get a majority of owners to approve it. And then you have to get the Department of Commerce to also approve it. And they are very particular. So don't let the 30 years pass. If you have, talk to a lawyer real soon. Preserving, you can do as soon, anytime. You can do it at 25 years, you can do it at 28 years, you can do it at 22 years. Just do it before the 30. I like everybody to do it now so that in 30 years from now, I won't be practicing, so I don't have to worry if your covenants lapse. Right now, I worry about it, so. Okay, so that is all that we had. A little summary. We talked about our purpose, duties, and responsibilities. So now, my question askers, I have this gentleman in the back in blue has had his hand up for a little while.
I have a question that live in the condos here, and they just had somebody move in, and they want to know if they have the right to be able to fly their drone on our property.
Oh, that's an interesting one. Okay. Can an owner fly a drone around the condominium property? I would say that the board can adopt regulations regarding whether or not they want to allow drone use, and if so, under what conditions. But it is common elements and common property, so that would have to be governed by the board. They can fly a drone in their unit.
Yeah.
Yeah.
I have a couple of their owners and they are visually impaired, both of them. We have washers and dryers that are put into our building through a company. They recently came out, switched out all of the ways that they can pay. They have to now use an app. These people cannot see on a cell phone to do this app. And they're blaming the association and the board for not providing them now with laundry facilities. And they want the board to do something about it. How do I handle something like that?
So that is a question that comes up. Sometimes somebody with a disability will say, I have been discriminated against because of my disability, or I've been wrong because of my disability. They have to ask for an accommodation. So they have to say, I would like you to change the rules to allow me to do this way. They can't just say, you changed something and now it doesn't work for me. Fix it. That's not your obligation. You have an app. If they need an accommodation from using an app, they have to propose to you what is the accommodation that they're looking for. I had something like this come up recently, and I can't remember what the issue was, but I do remember that it was somebody with a disability that were complaining that they were, something was not fair, and because of their disability, and we need to know what you're asking for. You need to ask us for an accommodation so that we can tell you yes or no. Somebody, question? Yes, ma'am. Oh, ma'am.
We just recently redid our elevator. And they put in cameras around, they're gonna add another one. Now, are the unit owners allowed to know where that camera is located if it's monitoring it?
So cameras in elevators. Okay, so you can have security cameras.
They said on the new, he had to put his camera
Code.
with the written
Reynolds County.
board on it, we can see and type.
You must have.
You have to have it.
You have to have it.
You have to have a camera in an elevator. I did not know that.
Yeah, it's a new law.
We don't even have to have an elevator to the.
No, we didn't go one in ours.
Somebody disagrees. I cannot speak on that because I'm not aware of a requirement. Obviously, if your elevator company says that there's a code that says you have to have a camera, then you have to have a camera. You have to comply with the code. But do your owners need to know where it is? I guess. Is it hidden?
Yeah, so you're hidden panels for your camp. And they're.
Well, I mean, I think you can accomplish that by just letting owners know. Don't be doing anything funky in the elevators, it's like on camera.
There you go.
Or if you want to be.
That's not.
All right,
How about cameras to the building, is that a material change, and has to be voted on by the owners or not?
is it a material alteration to install security cameras? I've seen mixed case law on that, but nothing recent, I don't remember recently. So security cameras, I would say, you can always err on the side of caution and get an owner vote. But if you have, if it's not a material change in the function, use, or appearance, I think, of the property, there's a case law provision that defines what is and isn't a material alteration. So that to me would be on the dividing line because it is a security issue and sometimes the security issue will trump the material alteration. But so that would be something I would ask your lawyer and tell them what you're proposing and what the cameras look like and where they're gonna go. And then they can review whether or not you need to get a vote of the owners. Yes,
How would you make the slides available to us?
we can email them, if you send a request to Jennifer.
And this webinar, a copy of this webinar will be living on our website, so you'll have access to rewatch this.
What's the website?
Vesta Property Services.
Okay.
You'll search under webinars and it will redirect you to a YouTube page.
Okay, great. Yeah.
Hopefully I didn't say anything wrong. You could live on in perpetuity. Anything, I'm just kidding. So, all goals. Anybody have any additional questions? Or are we ready to?
No.
Yeah?
Yes. There's, what are you going to do? 96 units. Okay. There's. And we're considered as a balcony, but they're also considered in the common elements.
Your balcony?
What are units? Not the smart unit. There's two entrances. Okay. But one units actually have common element, but they're balconies basically, not closed in.
Okay,
To put your, patio set up.
okay.
Now they want to take that away,
Who's that?
the board. They want to take it away due to the fact, because it's a common element. So my question was, patios that are on the bottom floor, are those considered hospital? And they said, yeah. But they can keep their patio furniture. It doesn't make any sense.
Okay, I'm not sure. That's one of those ones that sounds like we would need to look at your declaration and the definition of common element and then any rules and regulations related to your balconies. So that's not one, I agree with you. I don't know why you would have a different rule for one versus the other floors, but I can't really speak on that without looking at your
So I
documents.
believe at one given time, there was a house rule where the patios can have 2 potted plants, 2 chairs, and 1 small table.
Okay, so you would want to look at your rules. So if there's a question about this is about your limited common element balcony. So if you're in a condominium and you have a balcony, 99 times out of 100, that balcony is a limited common element. It is not owned. It is not part of your unit. So it is owned and controlled by the association. It's limited because it's limited to your use only. But the association adopts all rules related to that. So how much furniture, the color of the furniture, how many plants, whether you can hang things from the railing, all those are dictated by the rules that are adopted by the board. That's it.
Saying it's limited to the person that actually owns it, that belt of that corner.
It's called a limited common element. Anything that's called a limited common element means that it's owned by the association, but it's not available for access by all unit owners. It's either one owner because it's connected to the unit, or it could be a subset. Like I have condominiums that have residential units and commercial units. And so the pool and some of those other amenities are limited common elements of all of the residential owners. So they're limited because they're limited to residential owners and not residential and commercial. Most limited common elements are limited to the use of the unit to which they're attached. But that depends, so.
Parking spaces are limited to common elements.
Typically, yes, that is correct, yep. Well, this has been wonderful. And as usual, I have learned stuff, and I'm sure Mark has learned stuff as well while we're talking to you and hearing your questions. So I appreciate everybody being here and being on the Zoom. And yeah, again, my name is Michelle Reiss. This is Mark Saunders, Appleton Reiss. Our lovely folks at Vesta, we appreciate them for hosting, and we appreciate everybody for attending.
Thank you.
Thank you.